Good morning. It is a Friday. The first Friday of the new year. Happy New Year to anybody that I didn't see on my New Year's Day stream. You have been missed. I hope you have a fantastic 2025 ahead of you. We're already getting started in a good way, but also like not a good way, which is the sentencing is great, but what the other things that are going on in this case, not so much. Oh, Kez, thank you so much for being a member for 33 months. I appreciate that so much. Let me say hi to you guys. Hey, Nicholas. Hey, Tony. Driving to work, but listening. Be careful. Nicholas is wide awake at 6:22 a.m. Hey, Jennifer, good to see you. Let's see. And then Chick, good morning. Good morning, good morning, good morning, everyone. All right. So, for anybody that is not familiar with this case or like has slept a couple of times, like me, and might not remember all of the things, let's do a little recap. All right. So, back in April of 2016, 8 members of the Rhoden family were found dead. Okay. Um, and they were in 3 separate homes, 4 separate homes, 4 separate properties. The first 3 properties, or the first 3 homes, were on one property, but they were not in the same home. So it was different homes on the same property. It was a big piece of land that the Rhoden family owned. And so in the first house was Christopher Rhoden Sr. And then in the next house was, I feel like I'm going to get the 2 houses mixed up. Dana Rhoden, who is Chris Sr.'s ex-wife, Hanna Rhoden, who was 19, and Christopher Rhoden Jr., who was 16. And then the third house on the same property was Frankie Rhoden and Hannah Gilley. And then, like about a mile down the road, was Kenneth Rhoden. And he was found last. In fact, he was found way after the Rhoden family on the same property. And there were children in the home that survived. So Hannah Rhoden's 5-day-old baby girl was found in the bed with Hannah. And in Frankie and Hannah Gilley's home, their 6-month-old son was safe, and their 3-year-old toddler son was also unharmed. And it took a very, very long time for them to investigate this case and finally charge people. And who they finally charged were 4 members of the Wagner family. Billy Wagner, whose government name is George Washington Wagner III, Angela, his wife, George Washington Wagner IV, who is their son, and Edward Jake Wagner, who is also their son. And all of this happened because Hannah, who had been in a relationship with Jake Wagner when she was 13 and he was 18, had the audacity in Angela Wagner's mind to no longer be with Jake. And Angela had it in her mind, and she became obsessed with this thought that her granddaughter, the daughter that Jake and Hannah shared together, was somehow, some way going to be abused, and that the Rhoden family and Hannah herself couldn't protect her from that. And Angela wanted control. And that is really, in my opinion, from everything that I've read, from watching George's trial, which, by the way, George's trial I covered. There is a playlist on the channel if you want to go and check that out. But from everything that I've, read, watched, the trial, all the things, all the evidence that's been presented in court in George's trial, Angela was the one who ran that household. She ruled that household, to me, it seems like with an iron fist. She was the boss of everybody, and what she said goes. And once she became fixated on this idea that Hannah and her family wouldn't or couldn't protect her granddaughter, it's like a hamster on a wheel. She couldn't move past it. And she became obsessed. And so in that obsession, she planned these murders along with Jake. What's more unclear is, other than being at the murder scenes and actually unaliving people, which that one's here's the problem. So when George Wagner's trial took place in, what was that, 2021, you guys? Jake and Angela testified against George. That was part of their plea agreement. Okay. So their plea agreement was that if they testified truthfully against George and Billy, then the state would remove the death penalty from George and Billy's potential sentences. So, oh, thank you, Chicken Lady. Well, thank you for joining memberships. I appreciate that, babe. Welcome to the ward. Thank you for supporting me and the channel. I appreciate it so much. So it is somewhat unclear exactly, because I didn't hear Jake's testimony. And Angela's testimony, she would have only been able to talk about the planning of the murders, right? She wasn't there. She was everybody's alibi. So Angela, in April 2016, Angela is at home with everybody's phones, okay? And the first house that they approach is Chris Rhoden Sr. And Billy Wagner lures Chris to the door, where Jake and George are supposed to shoot him. They're hiding out by a truck. And I cannot remember right now off the top of my head whose gun it was that jammed, but I think it was Jake's that jammed. And so that caused Billy Sr. to be the one to have to shoot Chris Sr. And it was just probably a nightmare of epic proportions for Chris Sr. And then they moved systematically from Chris's house to Dana's house to Frankie and Hannah Gilley's house. And then the final house was Kenneth's. And how part of the reason that they ended up getting caught is because it was Jake's job to collect all of the casings. And in Hannah's bedroom, where she was sleeping, with her 5-day-old baby girl. 5 days, you guys. He missed one, and it was found under the baby's crib. And that's one of the things that led to them being caught, because in the interim between 2016 and 2018, when they were finally arrested, the entire family had moved to Alaska. And Jake had the audacity to get married. So, yeah, this was, hold on a minute. I need to share the screen so I can see if they're ready yet. We're still waiting. I think the hearing is scheduled. When I read about it, the hearing is scheduled for 10 o'clock, but I wanted to go live a little bit earlier to chat with you guys, and, do a recap and everything. So, Chicken Lady says, I don't know why my memberships are not renewing automatically. Mine do, but I think that it's some kind of setting that YouTube has now that you have to select that. I don't know. They're always updating and everything, and you know how that goes. So who knows? I'm sorry that that you're having to do it like automatically. That's a bummer. Be more convenient. But I guess if you didn't want to renew, like if you had memberships, obviously not to here. Just kidding. But circumstances change and you have to cancel memberships. I get it. So that might be actually a good thing, because then, you don't get good morning, Mr. Shine. Good to see you. That might be a good thing. Then you don't have to worry about that. Okay. So in the interim now, we've had George's trial has taken place. Angela and Jake testified, which Pretty Lies and Alibis purchased the transcripts of the testimony, and they sort of did a dramatic reading, as it were, of the testimony. It's which I completely appreciate. I just remember the day that Jake was going to take the stand, and the judge in that case gave each and every witness the option about how, if they wanted to be recorded in any way, whether that be video or audio. So some witnesses could opt, they didn't, opt in completely, in which, they would be streamed. And then some witnesses opted audio only. And then some witnesses, Jake and Angela, opted not to be recorded at all. And this caused quite the kerfuffle, and everybody watching the trial was irritated, including me, because frankly, I didn't think that Jake should be given that option. He murdered and admitted to murdering. It wasn't like Jake's guilt was in question at this point, right? It never really was in question, but at this point, by the time George was on trial, there was a plea agreement between Jake and the state. So I didn't, you're a murderer, and you admitted to it. So I just felt like he shouldn't get that option. And Angela shouldn't get that option either, because she admitted to being part of the conspiracy. I mean, she did a lot. She went and bought the most ugly shoes you could ever buy from Walmart, tennis shoes. And that's the footwear that they all wore. So, I mean, she was part of the conspiracy. She, in my opinion, is the one that it was her idea. I believe that she planned it. And it irritated me to no end that they weren't made to show their face. And the insult to injury, in my estimation anyway, about that is the reason that Jake's attorney gave as to why he didn't want to appear either by video or audio. Brace yourselves. Because he was in the county jail. And essentially, snitches get stitches. Utter, complete and total poppycock. And here's why. Because it was 2021, for Pete's sake. He'd been sitting in the county jail since 2018. By my count, that's 3 years of people in the jail. Well, they took their plea, I think, in, I don't know, 2020 maybe. Regardless, it was a known fact that he was going to testify against his family. So it had been known. It's not like this was a big, huge secret that he was going to, testify. So what's the big deal? Nothing had happened to him thus far. So what? He, if something were to happen, wouldn't something happen to him prior to testimony, right? If something were going to happen and he was going to be prevented from testifying, do you think that prison or jail justice waits? Well, let's give him come on, let's think about this. Let's give him, what are they sitting around in jail thinking, you know what, let's give him the benefit of the doubt, you guys. He hasn't testified yet. So maybe he's, let's not do anything to him until he actually, right now, he's just a suspected rat. We won't do anything until he becomes an actual rat. Shut up. That's ridiculous. Okay. So that annoyed me. And while I'm incredibly grateful that Pretty Lies and Alibis got the transcripts, because y'all, they were not cheap. Even just a chunk wasn't cheap. It's hard to know from text the tone in which Jake testified, his body language, all of those things that you want to see. You know what I mean? So was he sorry? Was he truly? Because people can say sorry. I'm sorry is an easy thing to say, right? They're not hard words. They're not difficult to pronounce. Even if you don't use the contraction and use the full I am sorry, those aren't hard words to say, right? They're not difficult. It's more difficult to say when you're truly sorry, right? And we can't see or hear the apology. So how can we know if he actually has remorse? I suspect that he has remorse in that he wishes he hadn't got caught, but that's about it. I don't think he's like genuinely sorry. I don't think he has actual remorse. I just don't. And the reason I don't is, the reason I think there's something like wired wrong in his brain is that when he went into Hannah's room, Hanna Rhoden, and he shot her twice, if I remember correctly. He took her 5-day-old baby out of the baby's crib and put her to Hannah's breast so that she could breastfeed. When he got to Frankie Rhoden and Hannah Gilley's house, and the only reason they were engaged and she would have been a Rhoden, but because her name is Hannah, it's to keep everybody's names straight. That's the only reason I call her Hannah Gilley. He took their 6-month-old son and put him in bed with his mother and his father. And when another family member came by the house to check on, she was there to feed dogs. And she went to the house, to Frankie's house, and their 3-year-old son was awake. So, he saw things. He saw his mom dead. He saw his dad dead. He saw, I can't imagine how scary that must have been, and how and confusing. I mean, he's 3. So would he remember? He will remember. Those things are indelible on the brain. It's just that I think what it's going to be is that he's not going to know. It's a feeling, an impression that he's going to have. I don't know that he'll remember. You know what I mean? And so I think that might actually be worse, to have this nagging thing in your brain, this like shadow of a recollection but not the full recollection. Like, I feel like if you have the full recollection, you might be able to, get therapy, and over time you might be able to, deal with it. But it's like a lingering thing that you can't quite see. It's just sad. The whole thing is sad, and it was unnecessary. Murder is never justifiable. Self-defense is one thing. This wasn't that. This was an annihilation, an execution while they slept. Ugh, it's disgusting. And I, like I said, I don't think anybody. Oh, and then I forgot about Rita. So Rita Newcomb, which is Angela's mother, will also be sentenced today. And her charges stem from forging custody documents between Jake and Hannah, and then lying to the grand jury. So that's what's going on with her. She'll be the charges that she's going to plead to is like basically obstruction of what is it? Obstruction of, hold on, let me look. I remember it's not obstruction of justice. It's something else. It's like obstruction of business. Hold on. Let me see. Where is it at? Let's see. Mm-hmm. Mm-hmm. Sorry, you guys. So Angela Wagner pleaded in September 2021 to conspiracy to commit aggravated murder, several counts of aggravated burglary, tampering with evidence, and other charges. 8 counts of aggravated murder were dismissed. Where's Rita? Here we go. Obstruction to an obstruction official business charge, which is a misdemeanor. Sorry, you guys, that was ridiculously long for me to try to. Hold on just a second. I gotta let Mac in. Give me just a sec. Excuse me. Okay. Sorry about that. That's the kind of quality professional reporting you're going to get over here. Quality content. You can't get anywhere but the board case studies. So while we wait, how about we do something really quickly? Let's do this.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash! Yeah.
Yeah. So give your girl a thumbs up or a thumbs down, whichever way you feel that I should get. Okay, hang on. They're in courts. Let me add this to the stream. Hold on. I don't want to add this though at this part. Let me make it bigger. Oh, and yeah. Okay, I just want to make sure I had the closed captions on. Y'all know how I feel about the closed captions. It's important. Okay. Now, here's the issue with what's coming up. Okay. So Billy Wagner's trial has, preparations, the motions, all the pretrial hearings, all the things they've been, going on quietly. And he was supposed to, his trial was supposed to begin in 3 days. Okay. There's been a change of venue filed. A new judge took over the case, and this is where it's an issue. So when this new judge took over the case, because the former judge retired, this judge decided, hey, this has gone on long enough, and let me tell you what I'm finna do. I am going to schedule, which is what we're here today for, Angela and Jake's sentencing. Now, Angela and Jake's plea deal hinges, right, on their truthful testimony at Jake and George and Billy Wagner's trial. Like, so what does this mean? Does this, and he also took the death penalty off the table for Billy Wagner. Now, that part of it is being appealed by the state, and it's working its way through the appellate process. I don't know that he has the I'm not sure that he can do that. Now, I am not an attorney, okay? So I've never seen a judge do that pre-trial. That doesn't mean it's never happened. It just means I've never seen it. So, and there is some talk about is it legal? Does it violate some type of constitutional right for the state? Hold on a minute. I'm sorry, you guys. Sorry about that. I got a little tickle in my throat. Can the state actually do this? Can the state hold the death penalty over Jake and Angela Wagner's heads of their family members? Is that lawful? Can they do that? Does that not violate some type of constitutional right? I don't know, to be honest with you, but that's what they're doing. And it, and by the way, George is appealing his conviction. He was convicted of 8 counts of murder and a host of other charges, conspiracy, burglary, all kinds of stuff. So, Jennifer, that's interesting about Kai. So, I have, thanks to my friend Rottweiler Investigations, you should check her channel out. She does interrogation videos. It's a great channel. I'll drop her link in just a sec. But she gave me Kai's, like all the things from his criminal trial. And there's a lot in that case that Netflix didn't show. But to be fair to Netflix, the purpose of their documentary on Kai was not really to talk about the case specifically, the murder of Joseph Galfney. What it was actually to talk about is how Kai the Hitchhiker came to be Kai the Hitchhiker and how he became sort of infamous. And then, like, basically the rise and the fall of Kai. That's really what the documentary was about. Oh, do you? Good. Oh, I'm glad. She's a great channel. She's a very good friend of mine. So that's really what the purpose, that's what the, point of the documentary was. But, so yeah. And I need to do the documentary. I need to do something with that. And I've been saying I'm going to do something for a very, very long time. And when I look at the case file, because of some of the things that are in that case file.
Mic check. This is a shotgun. Mic check. You should hear.
We hear you. I really think that I would have to censor a lot of this for it to be suitable for YouTube. And even then, I think that they would give me an age restriction, which is like not that big of a deal, but my channel is set up for, it's not made for children, 18 and older. That's what my channel says. But when you get an age restriction like that, it doesn't get pushed out. So I want people to see it because I want people to make up their own minds. And I think what I'm going to do, this is my big old Miss America answer to some question that wasn't even asked, is put it on Patreon. So, yeah. You know, it's interesting about Kai too, and that even with the oh wow. Hey, 1-800 Fraudbuster, good to see you. Long time lurker and never chatter. Yelling hello, Bindi in chat from snow-covered Sweden. Well, thank you for coming out of the bushes and chatting. I appreciate that. Thank you so much. Welcome, welcome, welcome. Snow-covered Sweden. Whew. We were supposed to get snow, but now they've taken that away and it's just going to be cold. So, well, such is life. But anyway, there are things that have come out subsequent to all of, to the aftermath of what happened that day and what made Kai infamous, that Kai may have actually, there's allegations that he actually egged, oh my gosh, I cannot think of his name right now, the gentleman on. So we'll see. I have to go through the case file again. It's been a minute. So yeah. But I'm curious if, okay, now don't do that, court reporter, like that. And also, I don't know who's working the camera, who's in charge of the camera, but I notice this a lot. Really? Oh my gosh. Thank you so much. I appreciate that. 1-800 Fraudbuster says, thank you so much, sweetheart. You have always been my go-to true crime channel. Oh, well, I appreciate that so much. Thank you. Okay. Like, I know that you got to do all the things, and this is setting up and we're, I shouldn't be critiquing, but I have noticed that there seems to be this situation going on with the camera people, and it happens during the trials or the hearings as well. We're getting Blair Witched, and I don't really care for it. Like, there is a quick zoom and there's a slow zoom. Could you please, you don't got to do it super slow, but could you find the middle ground? You're giving people motion sickness. We're getting Blair Witched over here. Slow your roll, camera person. Oh my goodness. I have completely forgotten about this hue of shade of carpet in this courtroom, which is interesting because the courtroom carpet is one color and the gallery carpet color is another. Honestly, it reminds me of Still Magnolias. That sanctuary looks like it's been hosed down with Pepto-Bismol. Pink is my signature color. Yeah, I know it's supposed to be, I think it's supposed to be red, but honestly, it looks like Pepto-Bismol pink in this lighting, which just, Exactly, Rachel. Don't try to listen. This is why I couldn't be a camera person, because I know there's many, many buttons on a camera, and I am a button pusher. When I see buttons, I want to know what they do. And the only way to know what they do, even if they're labeled, is to push them. I would be pushing all of the buttons. This is why I don't do that. This is why I'm not a camera operator. Pink is my signature color. Oh, Shelby, really? Oh, I just love that movie. Well, they're starting to file in. And I will say that I did watch. Hey, Bogart, good to see you. I did watch some things about, like, they were discussing all the things on Court TV a couple of days ago. And quite frankly, it was Opening Statements. It's that show. And they put it on YouTube, so you guys can go watch it. But the host and her guest said that Angela Canepa, and they also said, well, they said they accused the state of sloppy prosecution. Quite frankly, that's what they said. I disagree. I think that it does have a little bit of a thrown, but this is how it was, Rachel. Rachel says this courtroom has a thrown together look, right? Yes, it does. But this is how I had forgotten, but this is how it looked when George was on trial. And I remember them bringing George in through this door right here. And while the shirt may have changed, that dadgum black leather vest never changed. He wore that every single day of court, even when he testified. And the thing about George Washington Wagner IV that kind of has stuck with me all this time and throughout the whole trial was his absolute ability to sit right here in this chair. This is where he sat, and his two lawyers sat over here. And regardless of who was testifying or what they were testifying to, he made zero face. None. There may have been one time maybe where there was a flinch or a squint or something. But for the most part, Alice, excuse you, ma'am. Please don't claw my carpet. Alice says good morning to all of you. She's decided that she's going to start her day by tearing up my carpet, my rug. Appreciate that, Alice. You're the best. See, more quality content over here at the ward. Keep that in mind. Anyway, so no matter, he just gave no face. And the only other person that I've ever seen do that, and I'm talking about for hours and hours, like a full-on court day, is Chad Daybell. That's the only other person I've ever been. Most people, they might not make like huge expressions, okay? But Tony asks, I'm trying to remember what Shelby said on Steel Magnolias about her fingernail polish looking like a stuck pig. I mean, that's a normal statement in my world, bleeding like a stuck pig. Okay, so what she says is, Mama, this fingernail polish is drying way too dark. It looks like a stuck pig bled all over my hands. And then Malin says, I'm sure I have something that'll do. And Shelby says, it has to be delicate. And then Malin says, Shelby, if I don't have something that'll do, I will send your brothers down to the store to get some delicate pink nail polish. And Shelby says, oh, fantastic idea. I'd love to see what they'd pick out. That's how it goes. I've seen that movie so many times. It's my favorite. Now, you might be able to get some quotes from Steel Magnolias on other channels, but you won't get those detailed of quotes from Steel Magnolias on other channels. That is unique to your girl. So listen, going back to what we're supposed to be talking about, I'm not real super impressed with this judge. I think this judge way overstepped. And thank you, Tony. I appreciate it. Yes, Tony has been a day oneer. So is Chick. A lot of you guys have been a day oneer with me, and I'm so grateful for that. I think this judge way overstepped, quite frankly. I think that to take this measure and sentence, oh, now we're going to get a close up of the paneling. Fantastic. To take this step and go ahead and sentence Jake and Angela. Now, that being said, there's Rita. I understand that it is a right in the United States for a defendant to know their sentence. Like, they can't linger forever. But part of the reason that they're lingering has nothing to do with the state and everything to do with Billy's defense team. They're the ones that have postponed things. They're the ones that have filed motions, which they're allowed to do. That's all normal, procedure. But when that happens, then if there are plea deals that go with testifying, which these do, right? Then of course it's going to take longer. I mean, this isn't something that the state has done. And the way that the judge was like, well, listen, I'm going to get, sometimes and this is not a quote, but this was his overall tone. Sometimes the court has to, take the bull by the horns, as it were, and steer this, this can't go on forever and ever and ever. Right. And I think he overstepped in the way that he decided to take the reins and take the bull by the horns. And I guess you take the reins of a horse, not really a bull. Anywho, I mean, yeah. Bottom line is, I think he overstepped, because even when Judge Cranick did what he did to Sarah and removed her ability to have access to the public defender's office, he did that because the case had gone on for almost 5 years at that point. She had been through 1, 2, 3, 4 attorneys that all conflicted out, that all not conflicted, all filed motions to review or to withdraw. 4 of them conflicted out. And they were all saying pretty much the same thing as to why they wanted to withdraw. Because Sarah'd, and Judge Cranick was like, listen, if you think that you know the best way to handle your case, then go on and do it, girl. Go on and if you want 25/8 access to your attorney, then hire an attorney. And in the end, she was represented pro bono with that. And even Owen said to her a couple of times, the lawyer, Rachel Lee, which one is a cute old man? Even Owen said in open court a couple of times that Sarah understands that, yes, this is her, that this is about her, but that ultimately the lawyer, him, has the final say in trial strategy. He knows the law. So it is what it is. My colors are blush and bashful. One is a much deeper shade of pink. Boone says, that sanctuary looks like it's been hosed down with Pepto-Bismol. I like pink. Pink is my signature color. That's true too, Rachel. That is a great point. On top of everything else, Sarah couldn't take a minute to say thank you to Owens and his team. Zero manners. That be. None. She ain't got no couth. She ain't got no manners. She ain't got no sense. Just rude. But we can all sleep easy at night because Sarah Catherine Boone 10-10-7-7 forgives us. Bruh, who cares? You have to, Bogart. I know for a fact that it's on Max. You have to watch that movie. It is the best. There are parts of me that kind of miss Boone's antics, but listen, we have not heard the last of Sarah Boone. Okay, she's appealing, and I have a feeling that we're going to hear. There's going to be more letters. I have a feeling she's going to be unhappy with her counsel representing her that's been appointed. We're going to get letters saying something to the effect of, you know, they don't take my calls 25/8. They don't visit me 3 times a week and twice on Sunday. They're not doing what I want them to do. They're not filing the filings I think they should be filing. Because she did take a swipe at Owens, and I forgot to mention this when I was putting that video together. So when she hauls her cookies up to the stand and she sits down and begins her soliloquy, one of the first things that she says is that this is the edited version. I wanted to go over the more important parts, the things that were not stated during my actual trial. That is a swipe at Owens. You'll notice that Sarah brought up an essay by George and other like physical things that happened to her. Tripped, whipped, all those things, right? Those weren't brought up during her trial. They were, however, brought up when Owens would be interviewed. I remember him being interviewed on Court TV specifically and mentioning essay. And I think there's a reason why Owens didn't bring that up. See, lawyers are not allowed to lie. So if he were to introduce evidence of essay and he does not have good faith in his client that his client is telling the truth, or he knows that his client is not telling the truth, he cannot bring that up. So I think that I do think that there's something there. We'll see. So, all right, let's get this show on the road. Where's the judge? You know, the judge that needed to get a hold of the situation and, take control. So, yeah, let's go, Your Honor. We're ready. Yes, it's important. Sarah had to get up for work and her son's field trips foremost, which then we have that clip of Brian being like, I had to call her 11 billion times because, frankly, she's not reliable. I mean, that's not exactly what he said, but yeah. My apology. From now on, anytime I apologize, it's going to be profusely and ceaseless. My apology is profuse and ceaseless. It might be profuse and ceaseless, but it's also hollow and disingenuous. You don't mean it. You're not sorry. You're sorry you got caught. That's what it is. You're actually angry at everybody for seeing the truth in those videos that you recorded on your phone. Sarah, please stop playing with these people. Please. Because those videos, she really did think, she really thought in that brain of hers that those videos show her as the victim of George, and, she, there's the first video that they played where she wakes him up. Remember, she's very big, huge mad because George constantly woke her up. Constantly woke her up. But this day she woke him up. So you remember, that's how she starts it off. And she's berating him and how much have you had to drink and, yada, yada, yada. And there is a point where he scoots away from her. So exactly. I mean, she makes a lot of allegations. And I think that, so, I mean, we can just talk about this since we're just chilling and waiting for this hearing to start. But look, the O.J. Simpson trial changed a lot of things for domestic violence victims, okay? It made it where, and for the better, not for the worse. So most states now, and since the O.J. trial, have taken the position that when they're called out to a home for a domestic violence situation, somebody is going to jail. And they're no longer going to rely on the victim to press charges. That the state, even if the victim declines to press charges, the state is going to pick up the charges. It's not a fail-safe. There are other loopholes. For example, a victim can still sign an affidavit of non-prosecution. That does not mean that the state will drop the charges, but it does make it a little bit more difficult. Bottom line is, I think what happened in Sarah's case many times is the officers who came out there took it at face value. They took the situation at face value. They saw Sarah and they saw George. And at the end of the day, they're not forensic examiners. They're not, they're not medical examiners. They're cops. And so if you see a person, right, with injuries, and the person who has the injuries is claiming that the other person in the, that their partner gave them the injuries, you're going to take that at face value and allow, then what ends up happening is there's an arrest, there's charge, and there's a report made, and you let the DA sort it out, right? That's what I think happened. I think that there were times when Sarah called because George wasn't doing what she wanted him to do, and she had injuries on her that more than likely George didn't even cause. They were probably caused by her own self. Tripping, falling, being inebriated. And she knew that they would take her, that they would take her word. And so because of that, I think that she expected the courts to go right along with her, that they would see that George had a history of domestic violence charges against Sarah. And the one time when the officer said, wow, there's Jake, something ain't right here, and took Sarah, also, was, a huge wake-up call for Sarah. And then she did anything and everything she could to badger the heck out of George to get him to drop those charges and say what he wanted to say. I personally believe, and this happens quite frequently in trials, okay? We can't possibly know, unless it was recorded, every single detail of what happened that night. I don't think we've heard the truth out of Sarah. I stand firm in, I think that George might have been trying to leave. And the reason I say this is because of the items, the contents that were found in that suitcase. If the story is that you're filling a suitcase with items to donate, I cannot imagine personal paperwork and a syringe containing diazepam would be among the things that you would be donating. That just doesn't make good sense. Yes, you did, Nicholas. You did hear George correctly say, you can go see Boo. I have no idea who Boo was. Probably somebody at the bar. You're right, Rachel. Her arrest just fueled her rage. She learned nothing, and I think it ramped her abuse of him up. She never lets go of a grudge. Correct. Never. Wow, Angela looks quite different. Oh, yes, one of the friends who didn't show up to make a statement. One of her friends that George was keeping her from having. Meanwhile, yes, you can go see Boo. Mm-hmm. Excuse me, let me mute. Touche, Sarah Bellum. What do you mean she doesn't let go of a grudge? She forgives us. I have to say, personally, I feel forgived AF by Sarah. Like, I feel like I am enveloped in forgiveness. I feel like I've been bathed in a sea of forgiveness. I feel like Sarah Boone forgived the F out of me. Oh, Mr. Camera Person, you got swing. Didn't we just talk about this, camera operator person? Zoom out. Go slow. Slow. Jennifer says she won't forgive me once I finish my letter to her. I highly doubt that she forgives me either. Because I'm a content creator and I have blood on my hands and my keyboard. Shut up, Sarah. Like, for real? Oh, I wanted to drop a couple of links for you guys before I forget. Okay. So here is the membership link in case you're not a member and you want to become one. This link is to my pal Nadie, who makes the best music melts the best wax melts in the entire universe, and she's got her winter scents on the discontinued scent section, so they're discounted. And if you use my code Queen of Roasting, you get a discount. And if you want to throw a little tip your girl's way, here's my links. Also, my friend Allie. I don't remember if I did it as Al. I think so. I think I did it Allie. Let's see. Yep. All right. Good Lord, are we going to be getting to it sometime in my lifetime? I've been live for over an hour. And we're just, I don't know, I feel like a judge that wants to take control of things should also take control of being prompt. It's rude and disrespectful to be late. It's like you don't care about other people's time. I mean, accidentally is one thing, a few minutes is one thing, but 24 minutes? Come on, man. Let's go. Also, I want to say thank you guys all so much for being here. I appreciate it so much. This has been a long time coming, and this is not ideal. Like, I would have wanted to see this after they testified for Billy, in Billy's, not for Billy, against Billy in Billy's trial. I would have liked to have seen it that way. Hey, Kimberly, no, just me yakety yakking. Good morning. Good to see you. Yes,
So
there
before
is
you
a
go
new
to seat,
judge.
Will you please join me in the Pledge of Allegiance?
Oh, my
Pledge
stars.
allegiance to the flag of the United States of America and
To the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Go ahead and be seated. Good morning.
Hey, Rope Scout, good to see ya.
Good seeing you.
Yeah, no me gusta either. And I'm not liking this camera setup. Like, what do you got?
So there's three cases on the court's docket.
What's happening
today.
here?
2018 CR 158, State of Ohio versus Rita Newcomb. 2018 CR 156, State of Ohio versus Angela Wagner. 2018 CR 154, State of Ohio versus Edward Jake Wagner. The cases are set for sentencing today. Mr. O'Brien, I'm sorry, he's not here. Ms. Knepp is here on behalf of, there he is. Mr. O'Brien, how are you?
Yes, Your Honor, I'm not appointed on that case is scheduled for sentencing,
Okay.
so I will not participate.
You're
No,
welcome to sit wherever
Tony,
you
they
like.
don't.
Appreciate your experience. Ms. Knepp is here on behalf of the state. I'll introduce the defense lawyers as the cases are called forward. I asked everybody to say the Pledge of Allegiance this morning as an acknowledgement that this is a government function. Sentencing in criminal cases is exactly that. There's a lot of different perspectives in the courtroom. There's a lot of different interests here. But the one common bond that we have in this function is that it's a government activity. So if you can understand my responsibility is to come at it from that perspective, you're all entitled to have your own viewpoint. But that was the start of it. Sentencings in most cases have a certain amount of emotion. The more egregious the case, the more difficult the facts, often the higher the emotions. In high-profile cases, there's expected public discussion. It's not unusual for people to later on go express their First Amendment opportunities and rights to communicate with each other. Often that means, did the judge get it right? Did he listen to the defendant's side or the victim's side or the state side or whatever side they advocate for? And that's all appropriate for people to be able to have their perspective as a part of our First Amendment privilege. However, the right to public discourse really doesn't exist in this room outside the rules. And the rules are that decorum matters. So everybody's been well behaved, and I expect that to continue all the way through. As I explain the process to you, I'll expect you to follow the process. It's an open courtroom. The Ohio Open.
All right, let me just say this. I don't like it, Rachel, I can't highlight it for obvious reasons, but I agree. It's distracting. I don't care for it at all. No me gusta. And thankfully, I'm not in the courtroom. And so I don't have to have decorum, which I'm glad, I'm sure everybody is really super excited for.
I'll shut that down.
No decorum, Jen Lou.
Because in this setting, with emotions on all sides of the case, there won't be any spirited debate. That can all happen out on the street, but it's not going to happen in the room.
We get it. We're not going to act a fool. Got you.
Preliminary matters. I want to call attention to the fact that the court staff has done a fine job pointing me in the right direction, getting me to the right places, helping with scheduling. So I guess I want to acknowledge the Pike County Common Pleas Court staff, and then carry that a step further is to acknowledge the Pike County Sheriff's Department and the STAR transport team with regards to logistics and public safety. So to the extent that the sheriff provides a lot of resources, the court wants to acknowledge that also. The process today will be as follows. There's some legal matters to take care of with regard to Angela's case and Jake's case. Best way to introduce them that way. So I'll take care of those preliminary matters after the sentencing involving Rita Newcomb, because that's a relatively straightforward case. But with regard to the legal matters,
you're right. And so Zach TV, I
yes.
don't have to repeat it, but you know, sometimes we've been sitting here for a while, so I just felt like it.
Sentence Ms. Newcomb after hearing from her lawyer and her. Then I'll switch to Angela Wagner case. Work on merger. Then I'll work on Jake Wagner's case with regard to merger and sentencing. So we're going to do.
I don't like when it does this. Hold on.
Statement that applies to all of them, and then we're going to individually sentence 3 people. There's a lawyer here on behalf of the victims, Ms. Gall or Galley?
Yes, Your Honor.
Thank you.
Gall on behalf of the victims.
Gall, G-A-L-L-E, but Gall. Thank you for being here. The only unresolved issue is whether or not the victim representative, who you identified as TR, would like that person's identity or their statement to be televised. They have the right to confidentiality. So I just need to know for the media how you want to do that.
Your Honor, there are actually going to be 4 victims that would like to address the court, and for the Constitution and the revised code, they do have the right to be heard at any public proceeding involving sentencing, especially. And I can get citations for that if you'd like, but TR is actually not going to speak. It is going to be for others. I believe Angela is reading 2 of those statements on behalf of the victims, and then there's a mother that would like to speak, and a niece that would like to speak.
So let's have an understanding. I just wanted to know first whether they wanted to be seen or not. So can you answer that for me?
They have no objection to being recorded.
Okay, thank you. Thank you.
Why are you such a... Already, we're 2 seconds into you actually addressing a lawyer and or anybody in the courtroom, and you're being a jerk. I don't like this, Judge. This is going to be a very difficult sentencing for me. I've already lost my decorum. The decorum is out the window, and the couth is about to go next.
Now, the second question would be,
fucking rude.
Why at the 12th hour you tell me that you have other victims and you entered appearances for people you haven't entered appearances on? I'm going to give you what you want.
Jeez.
To a point. To a point. Because the obligation to come in and represent people doesn't mean to come in and change the script. So there's 10 minutes allocated to whatever 4 people are going to speak.
Hey, Nadine, my
I just need to have an identity
Good morning,
for
babe.
the record. If you want to use initials,
Where is MK?
the court
Let's go
reporter
get
their
him.
names, that'd be fine. But like you entering an appearance on behalf of somebody that doesn't want to speak really doesn't work for me. So don't answer that. Just understand that I'll give your 4 people 10 minutes, and I want their identity, and you want to give me initials, that's fine. Just write down their name so I have it for the record. Understand? Do you understand? Do you understand?
I need to make a clear record for purposes.
So you can make the record after we're done. Now, Do you understand what I just said?
Yes, and I'm
Thank you. Okay, then sit down. Thank you. So, with regard to Ms. Newcomb's case, it's Mr. Gerlach, right?
Yes, that's correct.
Nice to meet you. So, appreciate your representation, Mr. Gerlach. Any questions about the process, this recommendation from the state on all three cases?
Okay, I have to pause for fair use commentary, and I assume that if you're here, it's because you want to hear my commentary. But I'm just going to say this. This judge is rude AF. He has no couth. He has no decorum. There was no need for that. Okay? I can't, it's very condescending. And I'm going to say something else. The way that the judge speaks to women and men is very, very different. I find him to be quite rude to women, which I object to, being a woman.
Then the victim, then your statement, your defendant's statement, and then I'll sentence. Understand all that?
That's correct.
Does that work for you?
Yes, it works.
Okay, good enough. So, Ms. Konepka, go ahead.
I just want to clarify, Your Honor, you want me to make a recommendation for Ms. Newcomb?
All three.
Okay. I would like to first place on the record, Your Honor, I did not file a written sentencing memorandum as to Ms. Newcomb. However, I am making the same objection to the timing of the sentencing that I made in both Angela and Jacob Wagner's case, specifically, Your Honor, as this court knows, based on Gilbert holding. The agreement at the time that these agreements were reached between the parties, there was also an agreement that the sentencing would be delayed until after the disposition or resolutions of all of the remaining co-defendants in the case. At Ms. Newcomb's time in 2019.
Are you going to make a recommendation on sentencing?
I am, Your Honor, but
I got your objection. It's been in the record 5 times. I don't need to hear it again. It's overruled, so please make your recommendation.
The court is going to overrule me, but I need to make a record.
So, Mr. O'Brien, be ready to stand in, because there's no public debate today. The argument I'm hearing from your co-counsel has been beaten dead. It's been beaten dead. I asked her to make a sentencing recommendation. I asked her previously not to talk over me. The next thing that happens is she'll move to the back of the courtroom, and after that she'll be escorted out of the building, in which case you need to be ready to step in, because I'm not interested in old hash. She objected so many times, I have it in my sleep. I don't need it again. It's in the record. So I'm going to ask her again to make a sentencing recommendation on all 3 cases. If that doesn't work, then I'll take some disciplinary action. It's really easy to follow the rules until you don't have respect for the rules. So there's no debate today. We're just going to do this. I'd like you to be ready to step in case it doesn't work for her. Understand?
Yes, Your Honor. Only thing I would say for the record is that I'm not privy to the previous plea agreements on Jake and Angela and Newcomb, so I need some time to review those before I would if required.
I understand. Thank you. They're all in writing. Thanks.
Okay, and at least I think that Ms. Kenneth should be ready to proceed.
I hope so.
Recommendations on all 3 cases.
That's what I asked for. Now, recommendation.
Hold on a minute.
Certainly, Your Honor.
If I was Miss Canepa, you know what I would say? I would pull a whole Shelby in bed. Like, don't talk about me like I'm not here. Rude, man.
Regarding Ms. Newcomb, Your Honor, I'm deferring to the court on that. We did not have an agreed sentence in that case, and she has been very cooperative, and she did testify in George's case, and the case has been obviously pending for 5 years now, slightly more than 5 years now, slightly under 5 years, I guess, since her plea. And so I would defer to the court as to what Ms. Newcomb's sentence should be. As to Ms. Wagner, Angela Wagner, I'll proffer my objections after the court hearing so that I don't disturb the court any further on that. But I would simply ask the court to go along with the joint recommendation of 30 years. I know Mr. Craig has filed a sentencing memorandum in which he indicated that per a recent ruling, I believe December 9th, the court can only run 2 of the gun specifications consecutively. There are 6-year gun specs on multiple offenses, so of course the state would request that the court impose the 6-year gun specifications as the 2 counts. And then I don't really care how else the court gets to the 30 jointly recommended sentence. As to, I will note for the record that Ms. Wagner did appear and testify in her son's case, George Wagner's, in 2022, and the state believed, or believes still, that she testified truthfully in that case, so I would put that on the record as well. Regarding Edward Jacob Wagner, similarly, Your Honor, we would respectfully request, and I obviously did forward sentencing memorandums, that basically says the same things, but that we would request that the court go along with the joint recommendation in this case, which is specifically, and I provided a chart to the court, just because I know at some point the court has to create a sentencing entry, and outlaying what the maximum sentence is in each of those. That was the joint recommendation, is that he received maximum consecutive sentences. I think at the time that Judge Deering took the plea, obviously he also indicated he would be going along with the joint recommendations for what that's worth. And I believe during the colloquy with Mr. Wagner, he did ask him if he understood that he would that he would not live outside of prison. And Mr. Wagner indicated that he understood that. The sentence that was jointly recommended is the same sentence that his brother, George Wagner, got, and they are very similarly situated in that both of them went up on the hill that night and were responsible for the deaths of these 8 individuals, I should say, and on Fort Road. So again, Your Honor, I would respectfully request that the court impose the jointly recommended sentences. These were very carefully negotiated and constructed agreements. Both parties were fully represented, and these were the recommendations of all parties involved.
Thank you very much. So, Ms. Gall, how do you want to introduce your first victim? Initials?
Yes, Your Honor.
Okay, so who's first?
Andrea Shoemaker, she does not.
Oh, okay. Thank you, Ms. Shoemaker. Go ahead. Thank you, Ms. Shoemaker. Just stand, if you would. Right there is fine. The court reporter is the most important person here. She needs to hear what happened, so go ahead. Thank you.
Angela Shoemaker, Hannah Gilley's mom. You 3 helped plan, carry out, and murder my grandson, Ruger, who was 6 months old, laying in the bed between his mom and dad, Frankie Rhoden, Hannah Gilley, let alone your granddaughter's mother. How greedy of a grandmother are you? How greedy. You killed your granddaughter's mother. You're evil. You're evil. You are the spawn of Satan's. And the Satan is Billy Wagner. You are the evilest mother to help plan, carry out, and take the lives of 3 other mothers. My daughter was only 20, and you want 30 years of your life behind bars. 30? She was 20! 20! She never even got to buy alcohol. She got 6 months of her life with her kid. 6 months. And Hannah Rhoden, the love of your life, Jake Wagner. The love of your life. Your daughter's mother. She got 4 days. Kylie Rhoden got 4 days. Do you know what kind of questions I have to answer? First, it was bad people came in. Next, they seen your faces on the news. So guess what? I had to explain more. Because they're not kids, little kids no more. They're not 6 months old. They're not 4 days old. Bruder's soon to be 10. 10 years he's been without a daddy to teach him how to fish, to teach him how to hunt, to do all the man things. He has to depend on uncles, cousins. Because of you, Jake. Greedy Jake Wagner. You. I want you to suffer. This is what I want. And I've told all BCI. I want your mother to live and you boys to die as well as your dad. I want you to die so your mom feels the heartache of what it's like to bury a child. It's a heartache that never goes away. I hate you. You ruined my life. You ruined innocent children's lives. I hope you die. I pray every day you die. I pray your grandchildren and your children never want anything to do with you. And I hope they never do. I hope your daughter hates you with a passion and as much heart as I hate you, Jake Wagner. You shook my hand and acted as if you was my fucking friend. After you shot my daughter 5 times in the head. 5 times, man, while her son laid between them. And Hannah Mae, she's holding her little girl. And you shot her. How cold and evil. You are the spawn of Satan. I'll say it again. Spawns of Satan, you and your brother. And you, evilness, created them. And Miss Rita, I feel so sorry for you because I know you're ashamed to have such a daughter and grandsons that evil. Because you was the first to feel the guilt and say you were sorry, and it was your Christian duty to tell the truth. So I have not very many words for you. My heart breaks for you to have such an evil, controlled daughter and spawns of Satan.
Thank you, Mr. Maker. Who's next?
Actually, Your Honor, Ms. Canepa has 2 written statements that they requested she read, and then I do have one more live statement from Lisa Weisel.
Okay. Who's the first statement from Ms. Canepa?
It's Bobby Jolene, Your Honor, the individual who first discovered this whole experience has been absolutely devastating. I just want to make it crystal clear that I hate you and I will never forgive you for what you've done. You're a coward. I hope the rest of your life is absolutely miserable. You don't deserve to be alive. It makes me sick that you're allowed to breathe the same air that I breathe. You have destroyed my life and the lives of so many others. There's a special place in hell for people like you. You want to act like you're a Christian, God fitting me in, and that cannot be further from the truth, for God hates people like you. You are the devil. All of this is because of you and your mother on a power trip, fueled by the need to control that poor child's life. And now your daughter has lost everyone. She no longer has her mother, Hanna Rhoden. You've taken everything from that child that you were supposed to protect and provide for. Your daughter will always remember you as a monster and a coward, nothing more, nothing less. All I really want to know is why. Why did they all have to die? Why did you think you had the right to take 8 lives? I'll never understand it all. It feels like a bad dream that I'll never wake from. Congratulations to you, Jake. You have made your daughter an orphan and put yourself in prison for the rest of your miserable existence.
That's the end of the first one.
That's the end of the first one, Your Honor. The next
And
one. I'm sorry.
as you well know, the court reports ability to keep up with words, not as quick as we can talk.
I know you were limiting us on time, so.
Go ahead.
The next one is from Rita Newcomb, who is the
I'm sorry, I have to pause for a little commentary here. First and foremost, you dick. Why does he, so now he read it, now she's reading too fast. Are you kidding me, Judge? Bruh. Also, Mr. Camera Person, Miss Cameraman, listen, the camera operator, We know what Angela looks like. Canepa looks like what Miss Canepa looks like. Could you please spin the camera over to the defendants in this case so we can see their mugs when they're being read for filth next time? Thank you.
Mother of Gary Rhoden. I would like you to know that you killed more than 8 people. Kenny, Gary's father, literally grieved himself to death over the murder of his son and the others in the family. Gary was a good-hearted person, and he would give you the shirt off his back. He never missed his father's birthday or mine. He made it to every holiday. I truly feel that you did much more, so much more, these crimes than you're going to do. I ask for justice for Gary and the others in this family. Sorry.
Thank you very much. Last. What's your name, please?
I am Lisa Weigel. I am the niece of Chris and Kenneth and Dana. I am going to be speaking on behalf of the Rhoden family today.
Hey, Crafty
My family
Chris.
feels very strongly that some people have lost sight of what has brought us to this courthouse over and over again, year after year. Let me quickly remind you of the magnitude, the severity of this tragedy. This monstrous crime is the largest mass murder in Ohio. 8 people were brutally murdered, 2 young mothers and 1 young father. And I'm going to drop the face, please, I do. It is nearing the 9-year anniversary, and I assure you, no one wants justice more than our family. However, we do not agree with making hasty decisions to get it over with. We want all responsible parties to be shown no mercy, just like our family was showing no mercy. We can only pray that actions that take place in this courtroom today will not dismantle the justice that still has not been served. The Wagner family are master manipulators. It will tell of what the lies to fit their narrative. They are a true danger to society, and this crime is nothing to be taken lightly or play jeopardy with. And on behalf of me, and what I have to say, Jake, we are no longer a family. You've said that over and over. We will always be family. No, we will not. I will no longer ever think of you after today. When those doors close behind you, you will be an afterthought to the rest of our family.
Thank you, Ms. White. Okay, so Mr. Gerlach, you're first and your client, so go ahead. You can sit or stand wherever's comfortable.
Okay. I'm attorney Franklin T. Gerlach, and I represent Rita Newcomb in this case. She has cooperated with the court and the prosecutor, and if I understand it, there's still another trial, and she is willing to do what she has done before. Now, looking at her, she's already been in the jail approximately 8 days, I'm not sure, on the records. And for a year, she wore the ankle bracelet, and her movements and contacts were restricted. And she just recently had open heart surgery on the, which installed a new valve in her heart, and she's doing fairly well from that. She is on limited income. She gets $981 from Social Security, and we would offer to the court that perhaps the most appropriate thing would be a sentence that her service already be complete, and that there be no financial fine, because she really doesn't have the money to do that.
Did you want to say something? Thank you, Mr. Gerlach. Ms. Newcomb. Thank you very much.
And I'm sorry.
Stand up.
We just pray for all the trouble. I'm sorry.
Is it over? Okay, go ahead, have a seat.
And that would complete our presentation.
Hey, Violet, happy 2025 to you too, babe.
So
Good to see
this
you.
offense is called obstructing official business. It's a second-degree misdemeanor. Maximum penalty is 90 days in jail and $750 fine. So that's the way the plea agreement was presented to the court. Those are the maximums defined by law. The other charges, whatever they were dismissed, so they're of no concern. With regard to the outcome, the probation department's been monitoring her behavior since 2018 and gives no negative reports. So that's a crystal ball in one respect, because the past often predicts the future, but it doesn't have to. So their recommendation informally, without a full report, is that she continue on supervision. So I'll set a 5-year term of adult probation supervision, 180 days jail, 173 suspended, 7 days credit. So no additional time now. You can, however, Ms. Newcomb, earn the additional 173 days if somehow you don't take this seriously and don't report or violate laws. So there's a long list of standard terms and conditions of supervision that the court's going to, wait, let's go with I'm talking first and you don't. This is how the problems develop, all right? So you've been on supervision, but it doesn't count, the past doesn't count toward the future, that's pre-trial. The past does help me indicate I don't expect to see you again because the probation department seems to think you're not a problem. But I'm going to put you on supervision for 5 years and tell you that there's 173 days suspended in case you can't comply moving forward. I'm going to order the $750 fine plus the court costs, and then your ability to pay over time will affect whether it's actually collected. Because if I don't impose it today, I can't impose it later. Understand? The terms and conditions of probation will primarily involve your compliance with the law, reporting requirements, and then any education or training programs they think are necessary for you to be a good citizen, which in your case may not be a lot, but that's generally the purposes of supervision, is to help people become law-abiding people if they aren't already. So 173 days at risk, there's a $750 fine plus the court costs that have to be paid, subject to ability to pay. Understand?
Can I ask you a question?
Sure.
Do I have to go to jail?
You want to answer that or should I?
I prefer you say, but I think no.
No, unless you act out.
Oh, okay.
173 days suspended.
Okay.
But it does demonstrate a good point. What I think I'm saying isn't what people are always hearing.
But there will be a fine. And
Yeah.
if I'm bad, I'll go to jail. But if I can stay good, I don't have to. But I do pay the fine.
Yeah, subject to your ability to pay.
Okay.
Like, the point's not to put you in poverty. The point is to modify your behavior. If you have $30 left at the end of the month, then that should go toward the fine or the costs. At the end of the 5 years, if you can't pay it, you don't get incarcerated for being poor. It's forgiven at that point in time, but it is meant to be a punishment. Does that help you?
Yeah, I think I understand now.
Okay. Keep doing what you have been doing with regard to probation compliance.
But I still call in if I have to leave the state or something.
Or show up, whatever they say, you step and fetch it.
Okay.
Corrections or clarifications, Mr. Caroline?
Clarification, in the entry it says 90 days is the maximum.
I did say that wrong. It's 90 is the maximum. Yeah.
You said 170.
I did. It's 83, not 90 is the maximum. I said 180. I bumped it up 11, so 83. Thank you very much. My sentencing entry is actually back there on the desk right now, which doesn't help me here.
Right.
Thank you.
Hey, Your Honor, and I don't like to be disrespectful to the court, but this judge has just really, he's pushed my button. And why do you not have it with you? Why aren't you prepared? Because if it were one of these guys, particularly sitting over there at the state's table, if they hadn't had something in their hand right then in that moment, we would have heard for 45 minutes about how that made you feel. You know, how you're wanting to have this be all expedient and such. Ugh.
Thank you, Your Honor. So 97 credit, 83 suspended, $750 fine plus costs.
Okay, so Little Red. So what happened with her is she forged documents, custody documents between Jake and Hanna Rhoden, Jake Wagner and Hanna Rhoden, for the custody of their daughter that they shared together, and lied to the grand jury. So she was part of this. That was her role in this conspiracy. How much she knew and when she knew it is up for debate. But that's why she got what she got.
Yes, Your Honor. 5 years probation. Thank you for that correction. My apologies. No problem. Thank you. Ms. Canepa? Okay, you can check out right now if you would, Ms. Newcomb. That doesn't mean you have to leave the courtroom, just means I need that chair.
Oh, okay.
Thank you, Mr. Gerlach.
Thank you very much.
We'll switch to Angela's case next. And we'll need another chair. You can help us. I think we will.
It feels to me as if some of the judges' behavior has been, I think this is who he is in general, but I think he is being extra for the cameras.
You have co-counsel with you today, Mr. Burns? Are you by yourself?
Mark Hunt is not here today.
Oh, my apologies. Okay. So this is State of Ohio versus Angela Wagner, case 156. Mr. Crapence is here on behalf of the defendant. Mr. Hunt's not appearing, so we don't need the extra chair. And you had an opportunity to hear the victim's statement and the state's recommendation, right, Mr. Ferentz? Crapence, I'm sorry.
You're fine. I have, Your Honor. Thank you.
And you heard it also, right, Mrs. Wagner? You heard everything that was said before, right? Okay. I want to circle back on one thing, Mr. Crapence. Was there any part of the plea hearing that you thought was in error or deficient or you wanted repeated?
Yeah, at this time, nothing comes to mind.
Okay.
But
yeah, I wasn't here.
no,
But if there was an error, we can still fix it.
appreciate that.
Did you note anything that should be emphasized, Ms. Knapp? Any problems with the plea?
No.
Okay, thanks.
Wow.
So it's the defendant's opportunity to make a statement. So Mr. Crapence gets to go first, then Ms. Wagner, you get a chance, so go right ahead.
Your Honor, thank you. First, with respect to maybe some merger issues, I suggested in my sentencing memorandum that there are two sets of 2 counts each that we believe should be merged for purposes of sentencing. That was counts 16 and 18, as I recall, and I think 20 and 21. If I can read my writing here. And I won't repeat the arguments therein. I pointed the bill of particulars with the specificity of what actually was charged, and it seems to me that they are of similar import such that they should be merged. I don't know that. I have not read a response to that, so I don't know the state's position on that. With regard to the sentence or the plea agreement and maybe the agreement on sentencing, Ms. Wagner is very cognizant of the fact that this court is not bound by anything that happened before this court took over the following jointly recommended sentence. He did review it. He did say he would agree with it, but that in no way binds you. And my client is very aware that this court has the authority and the responsibility for deciding independently what the appropriate sentence is. So we do not walk in this morning expecting that this court will just rubber stamp the things that have happened before. But for the following reasons, I think that the court should accept the jointly recommended resolution in this case. As this court knows, these are horrible events. I appreciate the families being here and making the statements that they did. They have shown a lot of patience and I think maybe courage and repeatedly showing up for every hearing. I do appreciate that, and I know that their words do not fall on deaf ears. Your Honor, my client was involved with these actions. As far as her specific actions, she did not enter into any of these dwellings. She did not bring a gun personally. She did not pull a trigger. She did not directly cause the death of these folks. That said, she was aware of it. She took her own steps to try to assist in that plan. And that is something that she has taken responsibility for. In addition to taking responsibility, she has come into this court and she's testified against her son. And that was a task that was not very easy for her. It was important for her to do so, but it was also very important for the state. The state...
That's a lie. And sitting through George Wagner's trial, we heard about the relationship that exists between Angela and George. And let me just say for the record that Jake was her favorite. I don't think she gave a ras fat kneecap testifying against George at all, period.
Knew that the remaining cases after Jake had entered his plea were still not 100%, not an absolute win, because one person saying something sometimes without corroboration isn't enough to sway a jury to prove beyond a reasonable doubt. It's very important for them to have Ms. Wagner come in and testify and corroborate the testimony, the evidence, and the facts that Jake had testified to. Toward that end, after Jake had proffered, we never let Angela review the statement, the proffer, because we wanted to keep a clean wall between the two of them, such that she was not parroting back what somebody else had said. And I think it proved her value to the state as a witness. And it's because of those efforts that the state entered into this agreement, which I know the state probably didn't like, but felt it was necessary, and I think that they probably made the right call. Ms. Wagner has lived up to her end. She will continue to live up to her end of the deal, which again doesn't bind this court. I do want the court to know that she has provided me this morning with a list and some certifications of completion of some programs that she's taken while she's been incarcerated for a very lengthy time in Delaware County. And I count offhand, I'm not going to read them all, but I count probably 40 to 50 different programs that she has completed. She has found something of a niche, and she's been in one place so long. She's been entrusted to act as a trustee, but also has taken it upon herself to mentor young women who come in to jail, and then they come out, and they come back in, and she's told me many stories about the revolving door of women that she's met and been able to help. I believe that she, for the next more than almost 25 years of her life, will have a purpose. I know that she is the type of person who will listen, who will help to counsel, who will try to direct younger women into the right direction, a path that she hopes that they will take. She's done.
No, absolutely not. She is an evil, controlling woman who should not have access to counseling anybody. I wouldn't let her counsel a pet rock. She should be put in a glass case like Annabelle with a great big old sign saying, "Do not touch."
As much as she can possibly do to improve herself, her situation, and to give back. She has written a statement at the appropriate time. I would ask the court to allow her to read that as well. All that to say, Your Honor, I believe that the jointly recommended sentence is appropriate. I know that in the plea agreement, we had agreed to a specific sentence for each of these counts. However, as my addendum to the sentencing memorandum indicated, I don't think that we can follow that because of how the Supreme Court has interpreted the law with regard to firearms investigations. I did include, it was yesterday at some point, a suggestion of how to arrive at the same if the court is inclined to, and do so in compliance with what I believe would be the appropriate legal framework. Thank you.
Thank you. Ms. Canepa, do you agree that 18 merges into 16 and 19 merges into 20?
into 20?
Unauthorized use of property, that's the way it was suggested by Mr. Craypence.
Yes, I would agree that there could be an argument as to 16 and 18, but not the 19 and 20, Your Honor.
Want to argue that further, Mr. Craypence?
No, sir, nothing past the motion. Thank you.
Okay, thanks. So I looked at the bill of particulars and read the indictment and have all the discovery when I read through the trial transcript. I can agree that 19 merges into 20 and 18 merges into 16. So I presume you would have the court's sentence on the higher level penalties, Ms. Canepa?
Yes, please.
So 16 is a felony 3.
Okay, so to answer, Crafty Chris says, isn't sentencing a little late to argue responsibility? She has already been found guilty, right? She's pled guilty. And the deal was, okay, that the state made with Angela Wagner and Jake Wagner was that if they testified truthfully at George Wagner's trial, which is Angela's son, Jake's brother, and at Billy Wagner's trial, which hasn't happened yet, which is Angela's husband and Jake's father, Jake and George's father. If she tested, this is for Jake and Angela, if they both testified truthfully at both trials, the state would remove the death penalty option as a potential sentencing for for George and for Billy. Technically, according to this plea deal that exists, Angela and Jake shouldn't be sentenced yet because Angela and Jake have not testified in Billy Wagner's trial because Billy Wagner's trial has not taken place. So essentially what the defense attorney is arguing is, look, she's cooperated, she's taken responsibility, but at the end of the day, her part of this crime, which he's called it something else, it's a crime, was she didn't actually unalive anybody. She didn't take anybody's life. But Ohio has the law of principle. So that means that if there's a conspiracy that is established, each person can be charged as if they were the principal. They can all be charged with the same thing, even if they didn't actually take a life. Frankly, we'll talk about this more because I don't want to interrupt too much of the sentencing, but I'm so infuriated. I cannot even tell you. Here we go.
And 20 is a felony 4, so there'll be no sentences imposed on 18 and 19. They merge into 16 and 20. That being said, it's your turn, Ms. Wagner, for your statement.
Not too worthless, not too strict, not too controlling, not divorced, not too ungrateful. The perfect daughter, wife, mother, grandmother, perfect person. Always striving for perfection, thinking that was what was wanted of me. All of this had been stuffed down so far that I didn't even know who that woman was. I didn't realize I was so weak and flawed and broken that it would lead me to make rash emotional decisions. That when such a tragic event would happen within my family, I just froze. I couldn't think. I'm not saying this for justification, Your Honor. This is why it shames me to say at that point in time, I didn't consider the consequences of those actions would cause, or the depth of pain that they would bring upon the Rhodens or others. I know their pain must be unbearable. because separated from my family, the ones I love most in the world, brings me unbearable, suffocating pain too. And for this, I am so truly sorry. I can't undo what's happened. But the regret and the remorse that I feel is my daily reminder of who I once was and who I do not ever want to be again. Thankfully today, I'm not that woman. I've committed myself to change, to growth, spiritually, mentally, emotionally, to letting God be my guidance. Each day, I work on being a better me, rewiring my brokenness, living for a purpose so I can be filled with wisdom, knowing to slow down, to listen, and to ponder so I don't get carried away with any emotional decisions again. I'm not looking for perfection anymore. Now my desires and goals are for continuance of growth, for sharing the compassion and unconditional love to others that God shows me daily, and to remain this better me. God has opened my heart and my eyes. He has showed me what reality looks like. I've seen it in all the beautiful, unique women that I have met and been sharing housing units with. This world needs no more pain, so I give back any way I can, whether it is to show love, compassion, encouragement, a listening ear, a smile amidst their darkness, or just maybe by hearing my story, they will be enlightened of what real consequences made by emotional decisions looks like. My hopes and dreams are that I can make each day count for something good, to always move forward, not backward. Because all I am today, I have to give that glory to God. It's His love, His mercy, and His grace that has changed me. Thank you.
Go and have a seat. Stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes, and in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Are you kidding me? Did you hear what she pled to? Bruh, I have nothing. I don't even know what to say.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built-up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can.
I have to do it. I'm sorry. This might make people leave, and that's fine. But if I don't do this, I'm going to completely, absolutely, and totally explode.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
I'm sorry. The audacity of this man. Does that robe have extra pockets in it for you to carry around all this audacity? The condescension that you're showing towards the victim's family is disturbingly disgusting. I don't even have words. Let me just play this.
But maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, it's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 at Canada-Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above it. But good luck, because what I just asked isn't easy, as you well know.
Your Honor, no, not respectfully. I don't have to show decorum. I'm not in the courtroom. This is absolute, complete, and total, utter poppycock that is coming out of his mouth. I know that you just got on this case recently, okay? I get it, all right? But the things that have come out of your mouth just in the last, since I paused last, I was not prepared for. How can you look at the victim's family and talk about closure? How can you look at that when what you have done is put the prosecution of an instrumental part of this crime spree of these bootleg ass devil's rejects family, okay? The prosecuting Billy Wagner is going to be more complicated now, because I don't know what this means for Jake and Angela. They may not, they're going to be sentenced. They might not have to testify. And the only person who saw Billy Wagner pull a trigger is Jake Wagner and George, presumably, although George says he's appealing, so he's not fixing to help. What is wrong with you? Like, yes, I will, Charlie. What is wrong with you? Like, when you woke up this morning, when your alarm clock went off and you popped your eyes open and you sat up in this bed, in your bed this morning, was your first thought, man, I'm not fucking around today. I'm going to fuck some shit up. And then you thought, while you were taking your shower, of delivering this level of a speech? What is actually wrong with you, sir? What is going on in that brain of yours? I cannot believe, I've never been so livid with a judge in all of my life, which is saying something. So I'm fixing to be 48. Here we go.
With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will.
So what are you doing here? You're saying all of this because what? You're about to do something even more heinous? I feel like what this is a preamble. You know, when somebody says, don't take offense, I hope I don't offend you, something to that effect, and you know for certain that the next words out of that person's mouth are going to be so thrown off that that generations to come are going to be offended. That's what's happening here, I feel like.
We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines that courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is the second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Craypence is right to remind me of the recent case of Beatty. I saw that come rolling out the first week of December. Maybe that was in my entry 2 weeks ago with regard to having to follow the mandates.
Bruh, nobody gives a rat's fat kneecap about what came across your desk 2 weeks ago. Angel says, I have never seen a judge treat victims like this. I am in tears. It's disgusting. I've never seen this either. It's gross.
A lot of people might think judges have unlimited reign, if you will, to impose sentence.
Hold on a minute.
We have pages.
No, you don't have unlimited reign. You don't have unlimited reign to do a lot of the things that you did in this case, but you did it anyway.
And pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Craypence? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years. 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine your inability to pay. It makes that impossible, not only in the past but in the future. there's a legal obligation to pay court costs, processing, booking, pay to stay, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside, where you live. If you fail to comply, that can be a post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond the 10 years, which doesn't start running until you're released from prison. Did I overlook anything, Ms. Knappa? Mr. Crapin?
No, Your Honor. My client has signed an affidavit of agency coming in clerk.
Thank you. Yes, I'll hand this back to you. You can have the filing done.
Thank you.
Further evidence, Ms. Wagner, of how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. And in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You help the state make the case. Jake helped the state make the case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person that could have stopped the whole thing with one phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in.
Maybe you should have read through the discovery, because if you had, then you would know that while, yes, you're accurate in saying that she was the one person who could have stopped this because she had all of the cell phones, she was also the person who planned this. This was her idea.
Stop the whole thing. The depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case and the Rahab case is cited in the decision. They go back to 2017 cases. The Supreme Court made it really clear. Responsibility to cooperate. So for you, That's the only silver line. That concludes that case. Ms. Wagner, they're going to walk out the side door and move you on. Thank you, Mr. Craig Pence. My pleasure to meet you.
Thank you. My pleasure.
Have a good day.
I mean, he's what? Nice to meet you, Mr. Craig Pence. I don't even have words. Like, I mean, listen, I'm not saying that the lawyer in this situation, the attorney, the defense attorney, has a job. Okay, they take an oath. Everyone has the right to counsel. That's fundamental in our rights. Okay, and I understand that. But to do what he did, which is so above and beyond, especially given how rude he is to the state, I just can't. This guy. And this dude. Ugh.
Go ahead and have a seat. This is case 154, stated by Mr. Jake Wagner. Mr. McVeigh's here on behalf of the defendant, Ms. Roberts. The new tire is also here. Were you able to hear the state's sentencing recommendations and your statements?
Yes, Your Honor.
Did you hear them also, Mr. Wagner? Did you hear the statements?
Yes.
Did you have any issues or corrections you wished with regard to the plea proceeding, Mr. McVeigh?
No, Your Honor.
Think of anything on this case, Ms. Kenneth?
No, Your Honor.
Why are like?
Hold
on a minute. Why do you even ask that, Judge? Honestly, Your Honor, why are you asking that? Why do you even turn to Ms. Canepa and ask her anything, as if anything she says is going to make a difference to you? It's like a person who asks you how you're doing, but what they really want you to say is, I'm fine, and then for you to ask them how they're doing so that they can tell you all the things that are going wrong in their life. I don't like this judge at all. Not even a little. I don't even, ugh.
Attorneys to make their statements, you get a chance to make your statement, choose to do so, Mr. Wagner. So that's how we'll proceed, you understand?
Aw, hold on a second. Low Red says, my Frenchie Firecracker Jack started watching the TV, and as the word case said, he started talking, he recognized her voice. I guess he listens more than I thought. Well, did he seem happy about hearing my voice? Not just recognizing it, but being like, oh yeah, I like that gal.
I try to speak loudly enough, Mr. Wagner. I may not be doing that.
Oh, well.
Do you have a hearing? Do you have a hearing problem?
Yes.
Okay. I will try to speak louder and slower. But anytime you don't understand, do exactly what you did. Make it known.
Okay.
You can't miss this because of a hearing problem. Understand?
Yes, sir.
So thank you. Go ahead.
Thank you. We will do our best to make sure that he has full hearing and understanding and clarify anything that we may have some questions about. Your Honor, thank you for this time to speak on behalf of Mr. Wagner with regard to the sentencing. I will keep my remarks relatively brief. I say relatively because the nature of this case calls for certain remarks to be made. But nevertheless, we have filed a sentencing memorandum on his behalf. This court is well aware of all of the proceedings with this case.
He's got to be a pod person, Patricia. It's the only thing that makes sense.
The plea agreement that had been entered into, as well as a defendant's agreement that was entered into, and Mr. Wagner has complied with up to this date and would continue to comply with. Again, my remarks will be brief, not because this is not a serious case. No one could, in their right mind, argue to the board or anyone else that this case is not serious. And you spoke in terms of references to a master and that sort of thing. There are very few cases in the state of Ohio that would be of this severity. Certainly none that I have handled, or I've handled some multiple homicides involved. And, but out of respect for the
Aw,
family, parties, and all involved here, given that this.
Hey, sissy. Good to see you, babe. Hope you're doing well and staying warm because it's cold. Yes, cerebellum. So very curious to the male defendant and will allow him to interrupt the court. Mm-hmm.
Joint recommendation of sentence with the state of Ohio in this regard. That agreed joint recommendation of sentence was 8 consecutive sentences of life without parole for each of the aggravated murders involved herein. And it was also indicated that we would stipulate, agreed to waive and stipulate maximum consecutive sentences of both warranted, necessary, and appropriate in this case. I believe that probably would address the questions of merger. We know that Mr. Wagner knows that it's up to the court when it comes to sentencing. What I would indicate to the court is that he is fully aware that in entering the pleas that he did, he would be subject to a maximum possible sentence of 8 times life without parole, an additional 160 years if sentences were imposed to the maximum consecutive, and that 78 of the 160 additional years would be mandatory sentences. Again, the parties stipulated, or that we stipulated, Mr. Wagner stipulated to the necessity that consecutive sentence, maximum consecutive sentences were warranted, necessary, and appropriate in this case in order to effect the agreement of the state of Ohio. Again, Mr. Wagner understood what his maximum sentence could be. He understands and understood then that it would be up to the court as to what sentencing would be, but certainly he entered his pleas knowingly, intelligently, and voluntarily, knowing that he was subject to the maximum sentences as already addressed of 8 times life without parole plus an additional 160 years. He also understands that with the joint recommendation of sentence, and he understood this at the time of entering his plea, that with the joint recommendation of sentence, he would not be able to appeal the sentence of the court if the joint recommendation of sentence wasn't imposed by the court. So I think he sits here before you fully knowing what those possible sentences are. He did at the time of entering the plea, and knowingly imposed what the maximum would be.
Sends him to the maximum.
I believe I've addressed the issues of merger that the court wanted. Your Honor, I could stand here with myself and my colleagues in the Office of the Ohio Public Defender, having met with, and dealt with, and worked with Jay Wagner over the last 6+ years. There's many things that we could say. And I could reference that my colleagues had told me, or things that I could tell you about the meetings and conversations I've had with Mr. Wagner. But I think in all fairness and honesty to all parties involved here, that what probably speaks to Jake Wagner more than anything is the extent and the value of his cooperation in this matter. He referenced it in the sentencing of his mother, Angela Wagner, that without his information, perhaps convictions would not have been obtained, pleas would not have been entered, and the state wouldn't be in a position where they are today. So again, I think that speaks to Mr. Jake Wagner as much as anything I can say on his behalf here today. Your Honor, I believe that, at least by our calculations, we have 2,244 days of jail time credit. If that calculation is correct, I believe that was from a date of arrest of November 13th of 2018. I believe it's close if it's not completely accurate, Your Honor, and I support to take notice of that. The last thing that I would offer is that Mr. Wagner has signed an affidavit in receipt, if I may approach.
Yeah, please.
Has been notarized by myself, although I would have a notary stamp. We can see
you have a separate entry? Do you have a separate entry? You just sign them up.
We drive on to the board.
Your choice.
I don't have one with me.
I can do a margin note if you're satisfied with that.
I'd be satisfied with that, yes, Your Honor.
That's not your
Patricia, to that end, Patricia says this is such a complex and massive case to prosecute. To that end, I believe it is also the most expensive case in the history of the state of Ohio.
That's all you have, Mr. McVeigh?
Your Honor, I would just conclude by saying that, again, we did make a jointly recommended sentence. Mr. Wagner understands what his duties and responsibilities and promises have been in this plea agreement, in the defense agreement. I believe that Mr. Wagner is a man of his word. Thank you.
Ms. Roberts, care to add anything?
No, thank you, Your Honor.
Okay. Now, this is interesting, and I have to make reference to it because I also have to pause for fair use commentary. All right. Both Angela Wagner and Jake Wagner's attorney referenced keeping their word. To me, I'm wondering, does that imply that even though they've been sentenced, that they're going to continue to they're going to still testify against Billy in his upcoming trial? That's what I wonder. Because I'm not sure that they are legally bound to. I'm not exactly sure how this works, to be honest with you guys. I know that Law 2 will cover this at some point, so I'll check it out and get back to you guys on that.
With regard to merger, Ms. Netta, same argument, same discussion?
Yes, Your Honor.
Okay.
I suppose the court will reach the same conclusion.
Yeah, the same conclusion. So I think the merger is the same in this case as it was on Angela's. Academic as it might be, it's nonetheless essential to get it right. Your turn, Mr. Wagner. Anything you want to say?
Actually, Your Honor, I have a lot I want to say. But it's all right.
Just pull the mic, just pull the mic closer if you would, and try to keep your voice projected.
Can you hear me now?
Yes.
No, I have a lot I want to say, but if it's okay with you, instead of looking at you, I would like to look at the victims because they are who I really want to speak to.
You're entitled to do that.
You don't do that?
You can.
Oh, I can?
You're entitled to do that.
Oh, I can, okay.
Yeah, so whenever's comfortable, you can stand if you want, you can face them, you can face me. Just make sure no disrespect happens.
No disrespect, no.
Go ahead.
So, each and every one of you, well, not all of you, obviously, but I've had friendship or relationships with a lot of you, many of you. And I know full well that the weight of my crimes and what I've done to you and your family. There's no amount of apology I can give today, no amount of explanation, no thing I can do to help you with the pain you have, loss, anger, hate. Nothing can save that. But I'm not going to tell you, oh, this, and that. I'm going to tell you about me. Because, yeah, I used to be a manipulator. Ms. Gilley affirmed that, and I truly was. But after I committed this crime, I was still guilty. Ms. Gilley, I'm going to look at you because I feel you have the most hate. And this is for you. So whenever I committed those crimes, it was probably 2 or 3 weeks later, I was weighted down with the guilt I did. And I said the most sincere prayer to that day I ever said to that day. And I asked God. I didn't like what I did. Didn't like how I was living. Didn't like how the possibility of my daughter or even my nephew would grow up to be. And I asked God. I said, put me and my family back on the straight and narrow path by any means necessary. Any. And I can tell you today, I am not sorry I got caught. I'm sorry for what I've done. But I am glad I got caught. I 100% believe that it was Jesus who made me get caught to answer my prayer so he could become exactly who he's supposed to be to each of us. Lord and Savior. Because, Gilley, now I don't show much emotion. It's not in me. But quite how tonight, you've seen God, I do. I won't show much here. I'm kind of breaking up a little bit, but that's just me. I can tell you from my own experience, hate will not heal your heart. I'm not asking you to forgive me. I don't. But I ask you, if you are a woman of at least some kind of faith, you should really read the Bible, because hate won't do it. Hate will only condemn yourself. But I want you to know, what I want to tell all of you, is how I was, and how I believed, and how I truly thought I was going to die and go to heaven prior to being arrested. And how I learned in my own time, alone with Jesus, just him and his word. I set aside every human teaching I was ever taught, even John 3:16. And I read the word for myself. John 3:16 don't save you. The Bible don't save you. Only a relationship with Jesus Christ will save you. And he did not promise one place in his word. I don't know how many of you have ever read the Bible. He's never promised he would save you from hell. He promised that he came here to save you from sin, to unleash you from the captivity of sin. We're all weak. We all fall short of the glory of God. I knew that, and I was one of those people who believed, okay, sure, I'm a sinner, I'll sin every day. It's not like, why should I try? I ask for forgiveness when I eat, go to sleep, and I'll be good. I wasn't good. That's not what Jesus preaches. Jesus says specifically, you come to me with all your burdens, all of your sorrows, all of your pain, and you surrender, and he will heal you. You know, some of you might know the verse where it says you must become like a little child, or you by no means enter the kingdom of God. You must repent, or you by no means enter the kingdom of God. Repentance is what I thought prior to actually just sitting down and reading the Bible myself. It's not asking for forgiveness. That comes from repentance. Repentance is to choose to look at what you've done, hate it, and forsake it. Forsake sin. Nobody can say that they are a God-fearing Christian, born again, and think sin is nothing. At least little sins. Lying. Lying is just as much an abomination as any other thing. I've committed murder. I've committed every single sin that the Bible lists. Blasphemy, denying Christ, like Peter did. No, he never actually said it. But I have been in silence, and I heard someone else say it. It's just as much sin. Me? I'm going to tell you exactly how God changed me. And I know it's taking a little bit extra time, but I feel the judge will allow this. It took me about 2 months after I was arrested. And I read that Bible twice, cover to cover. And I did not like what I found. Not the fact that it doesn't give salvation, but the fact that I realized I did not have it. I realized I did not have repentance and never did. Yeah, I believe it was superficial. My superficial faith had no power to change, no power to save, no power to have godly works in my life. Not one bit. But I was deceived, and every time I read it prior to that, I kept deceiving myself. Well, John 3:16, I'm good. No. You gotta read John through 14, 13, all the way to 21. He tells Nicodemus about repentance. He doesn't say the word, but he tells it. Men don't want to repent if they don't want to come out of darkness. Because their deeds will be brought into the light and be reproved. That's repentance. You know what we ask Jesus to do? Save us. Change us. Because we're sinners. He does not call us into a life of sin and just save us from hell. No, he calls us into a relationship so that he can transform our life. So we will be adequate ambassadors of Christ on earth in his love and his forgiveness. Whenever, I've seen Miss Gilley's laugh, but when all of you guys can probably have the same feeling that she does. When she said that, no, I wasn't crying on my eyes. My heart was breaking for her, just as it breaks for all of you. Because you may be in the darkness that I was in. The hate is the darkness. And I can tell you, not in spite, but I'm not miserable. I don't live in misery. I've experienced your loss, I've experienced your pain. This is my mom mentioned, because I believe that God done this to me, so He could help me have the compassion and empathy to feel what you guys have felt. Shoot, He's taken my daughter from me, my nephew, those two more than precious people in my life. And He's done that, I believe, so that I would know how He feels about all His lost children. And that's what I do. I don't need to tell you about how good I am or this and that or what the things I do, because it's not important. I tell you this only because I care for each of you, each of your pain, each of your loss and your sorrow, because kind of like what they mentioned before, the judge mentioned, it's not about forgetting. The past is in the past. Strive for the future. But I can tell you this, I don't forget what I've done prior to my born-again moment. And I would describe it to you, but there's really no sense in doing it here. But whenever I was born again, I stopped forgetting. I didn't try to forget. I told my testimony to everybody I come across. I told it to them so that they may know that sin's not okay. Crime is not okay. It does hurt more than just us. It hurts everyone around us. Everyone we've known, people we don't even realize we're hurting. And there's a consequence to that. And I'm fully aware of my plea. I'm fully aware of the mercy that I've already received. And I am completely willing and ready to pay my consequence for my crimes here. But I want you to know that I have joy and peace and love in my life every day. It doesn't mean I don't suffer the loneliness or pain every now and then. It comes, and when it comes strongly. But I trust in God, because He gives me comfort every time it does. And what He does for me, He can do for you. And I'm not trying to make myself look big and think big shot on the news and all that stuff. Because I know everybody, not everybody, but many people are going to criticize what I say today. And don't get me wrong. Now you can see I cannot write this down. Because for the past 3.5 years, I have been thinking about what to say, how I can help you, not justify myself, fix it, or anything for myself, whatever the right word is, but how I can help you, each and every one of you, even my daughter, wherever she may be, everyone else who I've hurt. I want you to know the love and forgiveness Christ has for you, so that He can bring good, as He promises, out of this terrible situation to help those who still have the opportunity to be helped. And I'm going to tell you one example of that.
Mr. Wagner, start wrapping it up, will you?
Less than 3 minutes.
All right.
One thing, and I want to tell you, Sheriff, not all the details. But I came in contact with another inmate. This is after my plea. And he told me, because I told him, I'm confidential, I'm like, not necessarily how a Catholic priest does it, but what you confess to me, I'm not going to tell no one else. And he told me about he was going through a similar situation I was. How he was planning as soon as he got out, he was going to go kill his baby.
Stop.
Say what?
Wait. Okay. Go ahead. 2 minutes.
Well, I was able to spend time with that inmate a lot. And I was able to share with him what my consequences and the pain I've caused to so many people. And I was able to lead him to making a choice for Jesus and not to commit to doing what he said he was going to do. And you know, there's so many people out there who have gone through so many things that you've gone through, sometimes even worse than what you've gone through. And I've read of so many testimonies how they have brought God glory through the evil that has happened, both on my side, the offender, and even on the offended side, showing His forgiveness. And I tell you, forgiveness is a powerful thing. You know, so much the hardest heart you'll ever see. And I do that every day with my testimony, my fellow inmates, my brothers. I love them. I shout out to them. And I don't care how much I get persecuted for being called a snitch, being called everything under the sun. And it's odd because they don't criticize me for what I did, for the crime. They criticize me for taking the plea. They criticize me for standing up here and doing this, what I did for my brother. All of that.
Mr. Wagner, wrap it up, will you please?
My last sentence. I'm sorry. I just want you to know, Jesus has a cost. Obedience, repentance, and total commitment. And when you do that, as I've done, if you've all done it, I don't know, you will transform your life. I hope you all have been touched by that, and at least somewhat plant a seed that your hearts may be healed, at least somewhat. And I do pray for you all. That's all I got to say.
Have a seat. Thank you, Mr. Wagner.
Nothing further from the defense, Your Honor. Thank you.
All right, I have to interrupt because I let that go for his entire time and I didn't interrupt. But first and foremost, what I want to say is you're a piece of work, Jake Wagner. And the next thing that I want to say is to your point about your friend in the jail confessing to you, and you said that you wouldn't repeat it. Well, now that makes you a lying liar face who tells lies, who lives on Liar's Lane. Because you just told in open court on the record in front of God and everybody what he told you. So that's all that really needs to be said about what he just said. Disgusting. I pray for you. Ugh. I hope you can, just gross. Here we go. Let's see what this judge has to say about all this.
Very much. So, Mr. Wagner, that.
Also, I lied. I have one last thing to say. The judge didn't stop him because he was tired of hearing it or he wanted him to stop right there or anything like that. He told him to stop when he was talking about what the inmate told him because the sirens were going and it was going to be hard for the court reporter to hear it. That's why. Not because he thought what he was saying was preposterous and had no application to what is going on here, but that's why, so that the court reporter could hear it.
Allocution, that statement, further demonstrates the role the court does not serve. Everything you just said is perfectly appropriate. It's been heard many times before, as has the victim. But to the extent that there's a religious overtone, I don't factor in religious values. It's the same standard. The legal prescriptions, the laws of the government that I impose. I heard remorse. I heard your understanding and your explanation for it. But to the extent that you might, or somebody might have taken that as preaching, that's fine, except it has no meaning to me, except for remorse. If it was more than that, Mr. McVeigh helped me understand, but...
Excuse me, Your Honor. Where was the remorse? I didn't hear any remorse. Get the hell out of here.
It just demonstrates that the same ill will and rancor that came from the victims, and understandably, is now your faith experience on your side, neither of which is the role of the judge, the duty of the law. So it highlights what goes on in courtrooms on a regular basis.
Your Honor, what I might add to that, perhaps by way of further explanation, is that I believe from my conversations and conversations with my colleagues with Mr. Wagner, that the statement that he made there was, he wanted to speak to the victim's family, and rightfully so. But I don't believe it was in any way intended to sway the opinion of this court when it comes to sentencing.
We said the same thing different ways.
We did.
I can't accept that.
We did.
For benefit of the record, I'll lot of the victims in the gallery walked out along the way. Is there?
So it's fine for the defense attorney to stand up and put some things on the record, just to clear things up. But when the state wants to do it, that's all of a sudden a problem. Get out of here.
So they don't have to hear what he chooses to say. It's how it works.
Yes, Your Honor.
I think this day is more intense than many, but it's all too familiar on the criminal court documents.
Yes, Your Honor.
With regard to sentencing, Mr. Wagner, the court has the same analysis. Severity factors, well, obviously, clearly, there's more serious factors. There are no less serious factors. With regard to whether you're likely to be a repeat offender or not, I'm not going to have a crystal ball to project where you are after a long prison sentence. So I'll just find that the recidivism factors balance out. It's unpredictable, but I did the analysis and thought about it. With regard to the penalties to impose, count 1, aggravated murder, life in prison. Count 2, aggravated murder, life in prison. Count 3, aggravated murder, life in prison. Count 4, aggravated murder, life in prison. 5, aggravated murder, life in prison. Count 6, aggravated murder, life in prison. Count 7, aggravated murder, life in prison. Count 8, aggravated murder, life in prison. Count 9, conspiracy to commit aggravated murder, maximum 11 years out of Department of Rehabilitation and Corrections. Counts 10, 11, 12, 13, aggravated burglary, maximum terms of 11 years in prison. Count 14, possession of a dangerous ordinance, 3 years in prison. Counts 15 and 17, tampering with evidence, 3 years in prison. Counts 16 is tampering with evidence, 3 years in prison. Count 18 merges, so there's no sentence on 18. Count 19 merges, so there's no sentence on 19. Count 20, unlawful interception, 18 months in prison. Count 21, obstructing justice, 12 months in prison. Count 22, engaging in a pattern of corrupt activity, the maximum of 11 years in prison. And then count 23, unlawful sexual conduct with a minor, a 4th-degree felony because of more than 4 years of age difference. In that case, 18 months in prison, the maximum sentence. With regard to firearm specifications, the court's duty-bound under the recent case to impose mandatory 6 years on the first firearm spec taken from count 1 and 6 years on the firearm specification found in count 2. You're entitled to 244 days of jail time credit up through including today. You're required to register as a violent offender. You also have sex offender registration requirements. The sex offender registration requirements apply upon any release from prison, which would be for a period of 25 years, registering at least every 6 months with the sheriff in the county where you reside. If you change your address, take your employment, then you have to change your registration anytime you change your variable. The violent offender database, as you heard earlier, is a 10-year registration which can be extended. And if you fail to comply with the sex offender registration or the violent offender registration, that can be a violation of any terms of release or a separate felony at the time. The Chief Justice appoints retired assigned judges to work on cases where there's conflicts or problems. And I take that very seriously. It's a privilege after retirement to be granted the opportunity to come back and continue to help my colleagues. That's why I get out of bed every day. There's a need, there's a problem, maybe a skill to apply to resolve the need and the problem. That's how I got here. We talked about this with your dad months ago. I got 2 problems when I walked into this case. I'm going to explain the 2 problems. The first problem was a recommendation on your case that was the same as it was on your brother's, life without parole, which is what he got, right? How did he get there? He went to trial. He had 10 weeks of trial, and he had thousands of dollars. And dozens of witnesses, and emotional energy and staff energy, people energy, resources energy to get him to his conviction. Yet the recommendation here is the same, giving you no credit for all the cooperation that you gave. As Mr. McKinney said, you don't have corroboration of a cooperative witness, you may not have any case. So I have to resolve the first problem is how is it that I'm supposed to treat you the same when in fact you didn't act the same? That's the first problem. The second problem is how do I resolve the good deal that your mom got? 30 years is a really long time. That's a really good deal for the level of the conduct, especially since she could have stopped the whole thing dead in its tracks before it ever happened. And I don't let her off the hook because she didn't go to the scene. I put her equally responsible because the eyes of the law put her equally responsible. So my second problem is how do I resolve what looks to me like some sort of gender violence? And here's how I resolve it. I give you the opportunity of parole after 20 years on your prison sentence. So you do 6 on the gun spec, you do 6 on the gun spec, you do life on all the other counts, everything concurrent, with the opportunity of parole at 20 years. So 32 years out, you get your chance.
Oh my God.
Because you did something to acknowledge the responsibility for the crime.
Oh my God, this is, I can't.
That's not a deal, but that's as close as I can come to solving the problem that's handed to me by these ancient plea agreements. If everybody wants the last judge's sentencing deal, they should have sentenced him under the last judge. Everybody knew Judge Deering was gone right after the last trial. But nobody rushed it in to get it, and when I show up, I solve the problems the way I'm supposed to. So you get your chance to talk to the parole board 32 years from now. And then they do their job, whatever it might be. So I'm not going to sign off on a deal where you get the same for cooperating as your brother does for going to trial. There's the explanation. Court costs, processing, booking, pay the state. Medical expenses have to pay as a legal obligation. There's no victim restitution because they have civil remedies available. So you can go ahead and be excused. We're going to register you under both those registries, and we're going to take a break.
Are you kidding me? Did this man, we need a palate cleanser. It's coming. I have to do it. I'm sorry. I need a palate cleanser. Maybe y'all don't need a palate cleanser, but I do. Please hold.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
We've said this all morning long. It's clear that this judge has his own gender bias, okay? The reason that Angela got the sentence that she got is because in part she cooperated. But not only did she cooperate, but the state took into consideration her actual role. All right? And they felt 30 years was enough. And this rat Fink comes in at the end of all of this and decides, you know what? The state should have sentenced these two before the other judge retired. And since they didn't, even though their plea agreement hinges on their testimony, I'm going to go ahead and muck it all up and sentence them ahead of Billy Wagner's trial. Now we're fixing to take a break, and they're going to bring Billy in because there's some things that they need to resolve in his case. I believe that's what's next. I am effing floored. I cannot believe that this judge thinks that it is appropriate to even give this kid, I know he's a kid, I know he's young, a chance at parole. Because not only did he take the lives of 8 people, what did Chris Rhoden Sr. ever do to him? Like, his beef was with Hannah, okay? That's who his beef was with. And he took out her entire family, even making the extra effort to go to Kenneth's. And you know why? Because they were afraid of retaliation. That's what they were afraid of. That's why they did what they did. That's why all 8 had to go. And then, after he shot 19-year-old Hannah, he put her 5-day-old baby on her breast. He shot Frankie and Hannah Gilley in their bed while their child was in their bed, their 6-month-old son. How he didn't hit that baby is a miracle. That baby was covered in his parents' blood. And this boo-boo the fool thinks, oh, you know what? I can't predict recidivism. This isn't a situation where you need to predict recidivism. What he did on his first crime out, which I don't think was his actual first crime, because obviously being 18 with a 13-year-old is a crime in and of itself, but a violent crime, this might be his first violent crime. And this is what he does. He annihilates 8 people sleeping in their bed. They were defenseless. Disgusting.
We're going to go off the record. Thank you to the lawyers.
All right, let's move forward. Well, hold on. I want to see what's happening here. Hold on a minute. This is awful. Let me mute this or turn it down a little bit just for me. I am just absolutely, completely, and utterly floored. This is the most ridiculous level of utter poppycock that I've witnessed in a very, very long time. I just can't. That is such a slap in the face to the victims in this case and their families. I mean, granted, just because Jake goes before the parole board does not necessarily mean that he will be granted parole. But what it does mean is there's a chance. So as likely, he's got a 50-50 shot. Either he'll get it or he won't. And then he can continue. So this is never ending. That means that, let's put this into perspective here, okay? The victim's family members have attended every single hearing. They attended George Wagner's trial, every single hearing, and there has been many hearings in this case, and they have been there for them all. So now, thanks to this judge, every time Jake Wagner is up for parole, they will get notified. And every time they get notified, there will be a date set, and they will show up, and they will have to speak on behalf of their family members and beg the parole board not to give Jake parole, knowing that they actually have no control over it, that the parole board can grant parole if they choose. So every day they're going to have to relive that day in April when they were informed that 8 members of their family were dead. Every time Jake Wagner is up for parole. Every single time. This will never be over for them. When they had the original plea deal, obviously it wasn't ideal. What Jake did, what Billy did, what George did, what Angela did, is they were qualified to receive capital punishment. All right? And the family members, the victim's family members, accepted that if Jake and Angela spoke or testified truthfully at George and Billy's hearing or trials, that the death penalty would be removed not only from Billy and George, but also from Jake as well. And they accepted that. They said, that's fine. Life in prison for he'll never walk free again. He'll never get out of prison. He'll on his, own. He'll have to be carried out. He will die in prison. They accepted that. And now the judge has just re-victimized them all over again. And now they have to prepare in 32 years, which seems like a long time, but really it's not. Look at Susan Smith. I'm sure for the person doing the time and the family, the victim's family, they're doing the time as well. 32 years. It's unfathomable. I do not understand what in the actual F this judge is thinking. Other than, what is he? Some bootleg member of the Little Rascals? He's a charter member of the He-Man Woman-Hater Club? He holds Angela Wagner more accountable for not making a call than Jake, who actually pulled the trigger. At any time, Jake didn't have to go. At any time, Jake could have stopped it. He could have said, listen, my family has lost their ever-loving minds, and they're planning to murder 8 members of a family, including the mother of my child. He could have stopped it too. Any one of those people that was involved in this plot could have stopped it. But they didn't. So if you could go against the plea deal for Jake, then why didn't you sentence Angela harsher? If that's how you felt about it. You didn't have to follow the sentencing guidelines. You could, or the sentencing recommendation of the state. You could have sentenced her harsher, but you didn't. Why didn't you use that as a remedy? Why didn't you punish her harsher? You could have, but you didn't. I know that Miss Canepa has got to be completely seething inside. I know mine would be. My blood would be boiling if I were her. How she's able to maintain her composure after being spoken to the way she's been spoken to by the judge spoken to as if she weren't sitting right there at the table. He stopped her from speaking and turned to her co-counsel and addressed her co-counsel and said, essentially, bruh, your coworker over here, your team member might have to be escorted from the court. And if so, I'm going to need to put you in. You're going to have to do the speaking for the both of you. In front of her. Absolutely disgraceful what this judge has done. Completely disgraceful. And you do not get up in the morning, sir, to help people. This is not help. And if this, you like to say that past behavior is a good indicator of future behavior, I agree with you. So I heard what you said today. I've heard what you said in other hearings, and we're about to hear some more. So to me, you don't choose to get up and help people, especially when you get up and get on this, you take the bench and you say the things that you said to the victim's family. You condescended to them and gave them some, mealy-mouthed BS about, I hope this provides you some measure of closure. Any judge that's ever sat on a bench and been a criminal judge for any length of time knows there's no such thing as closure. Closure isn't a real thing. You don't heal from something like this. What you do is you learn to live with it. That's it. That's all. If that's healing, I suppose, but it's not healing. You allowed that worm to get up, look at the victim's family members, and address them by wishing that they find the Lord, essentially. Let him get up there and speechify and preach. He was 2 sentences away from rolling on the floor and speaking in tongue. And talking about, you've lost your daughter and your nephew. Are you drinking prison hooch or jail hooch? What's going on with you? You made choices, and that's why your daughter is no longer in your life. You made a lot of bad choices, one after the other, after the other, after the other, after the other. And this whole plan they didn't come up with this plan in one day and then implement it the next. This took a minute. At any time, you could have made a different choice, but you didn't. The reason that you're not in your daughter's life is because of you. And you're acting as if you prayed to get caught. You wanted to be caught. You prayed that your family would be put on the straight and narrow. I don't believe that for one red second, not even a hot second, not at all. I don't believe anything that comes out of that little mealy-mouthed crybaby worms. Ugh, I just can't. I just can't. Let's see what's going on X. I bet there's a bunch. Give me just a second. Let's look. I bet people are losing their brains over there. I would be. I'm mad. I'm seething. Let's search. Let's see what's happening over here. It's not going good. I don't even know what to say, you guys. Absolutely. And lying. That's another thing. All right. With the sneakers. So Angela buys these sneakers. They get found. Okay. Because I'm trying to remember how this happened, how they were found, I need to go back and do a more comprehensive coverage of this case, which, by the way, I did ask if you guys were down for that, and I did not get an answer. Hold on a second. Hey, Brandy, good to see you, babe. Hey, let's see. Because Violet asked, and I didn't, hold on, I didn't even see you guys' response, because I'm thinking that we definitely need to do it. We need to go through and do a deep dive. Oh, that's weird. My comment didn't even show up. Did you guys see it? I was thinking about doing a deep dive tonight. How do you guys feel about that? Okay, so I believe what they found was a receipt for the sneakers because there were shoe prints, shoe impressions in blood. And they were a very, very unique pattern. And they traced it back to this specific shoe that is only sold at Walmart. So then what they did was subpoena Walmart's records to find out which stores these shoes in these specific sizes when they measured the footprint, which Walmart sold this specific size. And then they got the surveillance footage from the specific Walmart closest to, I guess, the Wagner family, and they see Angela purchasing these sneakers. And then they find, so then they confront Angela with this evidence, and she says, well, I bought the shoes for the boys. And when she says the boys, she's talking about George, Jake, and Billy, her husband. And she said something to the effect of, they said these were the ugliest shoes they'd ever seen in their entire lives, and they would never wear them. And I threw them away. And so that's, Angela, that's my whole point, is like, Jake couldn't plan a fruit salad, for Pete's sake. He is not that bright. And in order for this plan to be carried out, it required the cooperation of everybody in the family. Okay, deep dive. I got y'all. We'll do a deep dive tonight. This required the cooperation of everybody. You're only as strong as your weakest link. So it required Billy sending a text to Kenneth Rhoden Sr. to get him to come to the door. Okay. So he sends a text to Chris. Chris answers the door, whereupon George and Jake were supposed to ambush him. But if I remember correctly, and we'll clear this all up, we'll clear this all up tonight. But if I remember correctly, it was Jake's firearm that jammed. Or it might have even been, was it Billy's fire? No, let me think. Oh, Jennifer, thank you so much, babe. I appreciate that. Thank you for gifting a membership. If you are the person who got the membership, please be sure to thank Jennifer for the membership. Thank you very much. Anyway, one of their firearms jammed, and that's when Billy had to take over. And so, but it was Jake who broke into all of the other houses. It's, George helped as well. George was instrumental in the move to Alaska. See, they all had to be on board with all of the plan, not just the plot of the murders, but what they were going to do after the fact. They were interviewed. All of them were interviewed after the murders, and they all stuck to the same story, which is why Angela Wagner had their phones at home so that they would ping on not only would they ping on the cell towers closest to their home, but they would also be on the internet as well. This was something that was thought out. They ran through many, many, many if then but clauses. This wasn't just something, this wasn't a spur of the moment. This wasn't, all willy-nilly. No. They had plans and they had contingency plans. What they didn't plan on is for Jake to have left a spent shell casing in Hanna Rhoden's bedroom under the baby's crib. That is what they didn't expect. And they did not, and if I'm remembering correctly, and we will clear all of this up tonight, the firearm that Jake used was an older firearm and also a very unique firearm. And they also modified their firearms with silencers. Hey, Shelly Bean, good morning. So, there was a lot to this. And I think that for the judge, I'm still like mulling over all of the things that he said that came out of his mouth. But for the judge to say, your mother, because she's the one who could have stopped all of this. All of them could have stopped it, Your Honor. What the heck are you talking about? She had all of y'all's phones. She could have called. Anybody could have stopped before they even actually left that morning. Hello? I mean, Tabitha, who is George Wagner's ex-wife, the mother to his son, right, who has been bullied, abused, and terrorized by Angela and George, showed more courage and conviction and character in her testimony than Jake Wagner has throughout this entire thing. I just cannot believe that the judge felt the remedy for Angela's lack of calling and putting a stop to this that nobody's talked about was to give Jake a shot at parole rather than just sentence Angela harsher, because he is correct. The state and the defense can come up with a plea agreement, okay? And they can have it all ironed out, all the I's dotted, all the T's crossed. But at the end of the day, it is up to the judge whether or not that plea agreement gets honored. And as you can see, he's under no obligation, and he made that clear multiple times. So why not sentence Angela harsher? Why not give her a sentence that he felt is indicative of the role that she played, the actions that she took or didn't take? Why not? Why do it the way he did it? It's almost as if he was looking for an excuse. I think he had this is just my opinion. I do think that he had his mind made up long ago, like right when he got this case about how this was going to go. I think that is exactly why he pushed up the sentencing. I think that is why he removed the death penalty from, excuse me, coffee. I think that's why he removed the death penalty from Billy Wagner's case, which was an overreach, in my opinion, and in my estimation. Legally, I don't know if he has the right to do that or not. It doesn't feel like he does. It feels like that if he removed it because there wasn't enough evidence to support capital punishment, that would be different. But typically, one of the criteria for capital punishment is that a murder or a death occur as a result of another felony, which is why they are all charged with burglary, because they did not have permission to enter those homes. And that is breaking and entering is a felony. And then in the commission of the breaking and entering, they committed murder, which then makes it a death penalty qualified case. So it's not like he took the death penalty off the table for lack of evidence. It seems to me like he took it off of the table because why should he? Why shouldn't he? It's like he's salty about something, and I don't know what he's salty about. Like, I feel like that Family Guy episode where Peter's listening to Lionel Richie. Someone has hurt you, Judge Hine. That much is clear. Who hurt you, Judge? Who hurt you? That's what it feels like. This feels like it's like personal and punitive, like he's getting back at somebody. It's ridiculous. It's disgusting. 32 years. So in 2016, Hannah Rhoden was 19 years old and Hannah Gilley was 20. So 17, 18, 19, 20, 21, 22, 23, 24. It's 8 years ago. So she would have been what? Hannah Rhoden would have been 27 and Hannah Gilley would have been 28. Chris Rhoden Jr. was 16. He'd be what? 24 now? 24. So what you're telling me is that a 16, 19, and 20-year-old's life is only worth 32 years. Their lives are only worth 32 years. Are you kidding me? Are you kidding me? We had no, and then let's talk about the children in this case. The daughter that Jake and Hannah share in common. Hannah's newborn. Hannah Gilley and Frankie's 6-month-old son and 3-year-old son. Because of the actions of the Wagner family, they have changed the course of those 4 children's lives. Because we'll never know what they would have, could have done with their lives if their mothers and their father had been allowed to live. We'll never know. Because when you lose your parent to violence at that young of an age, it makes an impression. It's permanent. Hey, Sprinkled Donut, good to see you. Yes, sneak in. Where is MK Lynn? I know he's on lunch. It's noon. But yeah. So this is a domino effect. He impacted Jake, the Wagner family, including you, Rita. You're not off the hook either. You did some mess yourself. Your Christian duty. To tell the truth. How about it was your Christian duty not to lie in the first place? How about if you hadn't forged documents? How about that? Like, why don't we start there? Ridiculous. Absolutely ridiculous. I'm going to look into it, Patricia. I don't know that they understood. Like, I agree with this, Lil Red. Lil Red says, a child that age can't understand. They internally deal with the aftermath. At some point, they outwardly show their anger. What I'm saying is, yeah, like they're at 3, 6 months, and 5 days. Obviously, they don't remember the events. Okay. The 3-year-old might have impressions of what happened, but doesn't remember it, won't remember it like we would remember something, like an adult would remember or an older child would remember. Okay. But they do know that they have to go on without their parent and they're going to be mad. You know? And think about this. All of those children in 32 years will be old enough to speak. And they're victims. So they will be notified when Jake is eligible for parole. That's another thing. Now, also take into consideration the child that Hannah and Jake have in common. At some point, because all human beings are curious and they want to know things, at some point she might just go on the internet and find out the details of this case. And how do you think she's going to feel when she learns that all of this was about her? That Angela Wagner, because you can't help that. Like I was listening to, it's not her fault, but human beings tend to take that kind of thing on. And I was listening to Shanna Harper's like documentary that she did for HBO Max. Okay. And she is the daughter of Wanda Holloway, who is the Texas cheerleader murdering mom. Back in the day, she conspired with her ex-brother-in-law, who became an informant, reported it, but she wanted Shayna's cheerleading rival, Amber Heath's mom, Verna, unalived. And Shanna kept saying in her interviews, she said it multiple times, that she carried around all of this guilt because she felt like if she would have been better at cheerleading, if she had just made it, then if she would have just made cheerleader, then none of this would have happened. So, I mean, it's just all of this has such long-reaching consequences and ramifications for truly innocent people. Children are truly innocent. And I worry for these kids. I do. I do. Because even when Elizabeth, who Jake ended up marrying when they moved to Alaska, and Elizabeth took over the role of mother, which Angela was expressly against. She did not like it at all, and she did everything she could possibly do to drive a wedge between Jake and Elizabeth, and more importantly, between Elizabeth and Jake's daughter. Because when Elizabeth testified and she spoke about the relationship she had with Hannah and Jake's daughter, you could tell that she really did love and care for that little girl and worried about her, especially because of the loss of her mother. She really doted on her and she was worried about her and she looked out for her. But Angela Wagner would not have it. Angela wanted to be her mother, not her grandmother, her mother. And that's another layer to this whole situation that, needs to be discussed. Is that fact as well? So annoying. The whole thing is just disgusting to me, and I'm just so angry about all of it. I just worry for all of them. I worry for all of them. Knowing that in 32 years, Hannah and Jake's daughter is going to get contacted because her father's up for parole for the murder of her mother and and her uncle and her grandparents, her uncles and her aunt and her grandparents. She's going to be contacted. She's a victim. She'll be notified. And can you imagine the conflict in a person? Oh, so I'll tell you. Jennifer says, I missed something. What are we waiting for? I will tell you. Un momentito. Hold on. Let me go back. Okay. Let's see. Let me go back up here. Scrolled too much. I scrolled too much and went, bruh, what is going on with my phone? All right, hold on. All right. So 2 key decisions remain pending in the appeals court. Whether Judge Hine can dismiss the possibility of Billy Wagner facing the death penalty against the state wishes and without them requesting it in an official motion, which is not why we're here today, but also whether he can move the trial out of Pike County against the wishes of a victim identified only in court records as TR. But he is going to be also hearing some things today. I just can't remember. Let me see. Where is it? Okay. Following Friday's sentencing, a hearing is scheduled for Billy Wagner. It could be announced in that hearing if Judge Hine will move his trial to another county after saying he didn't think that an impartial jury could be seated in Pike County. So that's basically what we're hearing today. I think that the judge in this case has overstepped every single, like the line is so overstepped at this point that we can't even see the line. He's gone so far past the line that we don't even know where the line is anymore. I just feel like this, he doesn't really have the right. And I'm not talking about like morally, I'm talking about legally. I don't think he had the right to do what he did as far as removing the death penalty. I also don't think that he has the right to decide all of the sudden without anybody that, okay, we're going to move the trial, especially when there's a victim who it's TR, so it's got to be a Rhoden. The R has got to be Rhoden, but I don't know what the T is. I'm trying to think. I'm sure if I thought long and hard enough about it, I could figure it out, but they don't want to be identified, and so I'm not gonna. How about that? But it's obviously a member of the Rhoden family, and victims have a right to attend the trial, and it does put undue hardship on the victims when they have to travel, and that's just facts. Now there is the the victim advocate, the victim's rights that are part of the state, that there's funds for travel. But what if the situation isn't about the financial means to be able to travel, but perhaps they're not well enough to travel? What then? I do think that Billy Wagner's lawyers started they're the ones that filed a change of venue. But if I understand the rules correctly, in any high profile case, the initial file will be to request a change of venue. But it is my understanding that just because the case is high profile, that's not enough of a reason to automatically grant a change of venue. A change of venue is expensive. It's expensive for the county who's prosecuting the case, because it's on their dime to move it. So when they, what I don't understand is if he's worried that he can't get a impartial jury in Pike County, then rather than doing a change of venue, there's a second option that judges have where it's basically they go outside of the county to another county and they get jury members, potential jury members from that county. And it seems like why wouldn't that be the thing to do? Why would we just automatically be like, okay, we're going to move this whole court. We're going to move the whole case. Like, I don't understand that. There's other remedies, especially when you know that one of the victim's family members is asking you not to do a change of venue. You have other remedies. Why do you have to be a jerk, Mr. Hands? That's who he reminds me of for real. Oh yeah, I agree, Jennifer. I think he couldn't care less about the victims. When he made his little speech about, removing emotion, that's a given. Okay. You can't use, like, a judge can't use emotion, to make a ruling, right? He's bound by the confines of law. However, as we see with other judges who are empathetic and sympathetic to the victims, one judge in particular springs to mind. That would be Judge Werner, who presided over Colorado versus Letitia Stout. While he was bound by the law in her sentencing, he obviously could speak to her crime and as to why he was sentencing her the way that he did. And he did speak passionately and he did speak with emotion. So, it's just it's just a huge slap in the face. This judge is disrespectful AF. And I'm over it, completely over it. Like, he needs to vamonos. He shouldn't be presiding over this case. The only thing I didn't have an issue with Judge Deering. The only issue I had was Judge Deering allowing Angela and Jake to testify with no recording of it other than the court record. Like, I felt like the compromise should have been, okay, you don't want to be videoed, fine. We won't video you, but we will hear the audio. Oh, did you, Low Red? Yeah, I mean, I have there are some judges that just really stand out to me for their compassion. And when it comes to dealing with particularly difficult and heinous cases, and the murder of children is, I think, one of the worst things that the worst crimes that can be committed. Yes. And Judge Hyland in the Chandler Halderson case, and even Judge Kranick in Sarah's case. You know, he was stern about outbursts because he had to be. That's part of the judge's job. They've got to keep the courtroom under control. That's their job. And I understood that. But he used his judicial discretion when it came to sentencing, in that he could have, if he'd have chose to, he could have read Sarah Boone for absolute, total, and complete filth. But he chose not to. And I think the reason that he chose not to is because, let's be honest here, this ain't Judge Cranick's, first trial ever. This wasn't his first day on the job, right? He's seen a lot of things. He's one of the things that he presides over is domestic violence cases. And I think that in his capacity as a judge and also just as a human being, because even though, we're supposed to not rule based on emotion, he's still a human being and he comes with his own experiences. I do think that based on all of those circumstances, I think that he knew that that is what Sarah wanted. That if he would have read her for absolute filth, which we all would have enjoyed, then Sarah would have used that to further propagate her victim narrative. And yes, Judge Jennifer Duros, was that her last name? I mean, she explained things to Daryl, the amount of patience that she exercised with Daryl Brooks, the outbursts, the repetitive arguing the same thing over and over and getting, she was just incredibly patient with him. Doro, thank you. All right, here we go. Yes, Rachel. Rachel says, we've seen so many great judges. It makes this kind of thing more shocking and upsetting. Yes, because this is not what most of us are used to. I mean, yes, do judges make mistakes? Obviously, they're human beings. They're not infallible. But it feels like this judge has an axe to grind, like he's punishing the state. That's what it feels like. And by extension, some of the things that he said to the victim's family members felt like he was irritated that their loved ones were murdered and that he even had to be dealing with this in the first place. That's kind of how it felt. It's just mind-boggling. I don't even know. But rest assured, y'all, regardless of what takes place today, it's going to be covered. I will be covering Billy Wagner's trial, wherever it has to be, whatever decision, whenever it is and wherever it is, I will be covering it.
Okay, go ahead, have seats.
Yeah, okay, let's see what poppycock Judge Hines going to come up with.
CR 157, State of Iowa v. George Wagner III. Set for motion hearing today. Mr. Collins, Mr. Hayes, Ms. Anstead, Ms. Stevens are here for defense. Mr. O'Brien, Ms. Kenneth are here for the state. I think there's two matters for the record. First is the defendant's motion from last December, renewing a motion regarding other acts testimony. So it'd be like the scope of disability. And then the court's wanting this to hear re-argument with regard to the death penalty specifications. So we'll try to knock those two things out of the ballpark here. I don't know, Mr. Collins, Mr. Hayes, you want to talk about your motion? I think it's pretty much oral argument, but maybe it's hearing, but evidence.
Thank you very much. I please the court on behalf of our client, Your Honor. We received the government's response to both of these things last night. I didn't look at it this morning around 8:30. So with the court's indulgence, we kind of split this up. We're going to let Stevens make the argument, the oral argument. But I guess would you? I'm sorry.
I didn't see any of it yet, so you're still ahead.
Okay.
Go ahead.
Would you like a copy?
You're probably just going to get in the way, so we're good. It might have been filed. I just don't get things because I don't have a staff.
I thought I emailed it to you at the same time.
You emailed me at 12:36 last night. It's in my inbox. I left to get here at 6 this morning. No problems. I just don't live on the web. Yeah. Yeah, like I'm good with all like not finding fault with anybody. I'm just saying you're ahead of me. I read the motions. I looked at this.
Hold on a minute.
I'm already trying to form.
Wait a minute. Back the milk truck up. There have been motions and responses to motions filed, and homeboy hasn't even read them, but you're going to rule on them?
Yeah, please do.
So I guess with the court's help, Your Honor, we didn't know, Ms. Canepa, the government broke it up into chunks and argued 7 or 8 other acts.
It has handwriting on it. So
Oh, I'm sorry.
Do that.
Sorry about that.
Thank you.
You wouldn't be able to read much. The government, Your Honor, took each concept in different chunks, and there's maybe 7 to 10 other acts in each of the chunks, so we either argue in chunks, Your Honor, or in big areas, or if you'd like us to go through every single other act, we're prepared to do that as well.
This judge blows chunks.
February of 2021, so Ms. Stevens can address that, or we can talk about each one, whatever the court would entertain.
I should just start globally, chunks, if you will.
Thank you very much, Your Honor. May I proceed?
You sure can.
May it please the court. Firstly, Your Honor, the state of Ohio in its response relies on a Supreme Court case decided in 2020, State v. Hartman. And we would submit, Your Honor, that the Hartman case is absolutely instructional for this case because it held that other act evidence was inadmissible. Evidence of the same character that we submit that the state is seeking to introduce with this other act evidence. In addressing, Your Honor, the state's first chunk of an argument, it uses identity. And it uses identity as an umbrella argument, stating that identity is an issue in this case. However, Your Honor, we would submit that just because identity is an issue in this case, it's not a license for a prosecutor to introduce any type of allegation going back in perpetuity against the defendant. And that's what we have here. The state of Ohio has evidence in the record contrary to modus operandi or the identity of the other act evidence in which it seeks to introduce. In the Hartman case, Your Honor, the Supreme Court held that similar act evidence is only relevant
Thank you, Your Honor. I apologize. In the Hartman case, the Supreme Court held that similar act evidence is relevant only if the jury can reasonably conclude that the act occurred and the defendant was the actor. In almost every other act that was listed in 2021, our client, Your Honor, Billy Wagner, was not the actor of the other act evidence that the state of Ohio seeks to introduce. And the state has evidence, Your Honor, evidence in the record that Billy was not there. Billy was not present for this conversation. Billy did not threaten. That Billy lived with his mother at the time that the state is seeking to introduce these other acts. Identity, Your Honor, as the court is aware, is a permissible purpose under 404B when there is a modus operandi, when there's evidence, indicia of modus operandi. We would submit, Your Honor, that none of the information, none of the other act evidence that the state has provided conforms with, shows that there's a modus operandi here. As the court's aware, modus operandi means literally a method of working. Evidence, Your Honor, that the defendant has committed uncharged crimes with the same peculiar modus tends to identify the defendant as a perpetrator of a crime, a fingerprint, or a signature, if you will. The court may have heard it as a strikingly similar doctrine. An example of such, Your Honor, of a modus operandi type for which another act can be admitted into a trial would be something like a fingerprint or a signature. A serial killer shaving the head of his or her victims after every killing. Taking trophies from every type of murder. That is the modus operandi, and that is the exception that the Supreme Court of Ohio contemplates. But the state argues that identity here is absolutely an issue, and that therefore modus operandi is an issue. We would submit, Your Honor, that modus operandi is not an issue. The utility of modus operandi, Your Honor, comes from its connection with the current crime through shared characteristics that make the conduct unique to the perpetrator. Here, Your Honor, the accused perpetrator is Billy Wagner. There is no fingerprint, like of someone who is not our client, hacking a Facebook. And these are just examples, Your Honor, of the other act evidence that the state is trying to introduce for Mr. Wagner's trial.
Okay, so just in case you guys don't understand like what she's talking about, there were times when the planning of this crime occurred there where it doesn't appear where the defense is alleging that Billy Wagner was not present. Okay. And they're trying to keep a lot of the conspiratorial elements, the other crimes that went along with the planning of this crime that the defense is saying that Billy wasn't a part of, out. For example, they don't want in that Angela Wagner was so fixated on and controlling George and Jake's girlfriends or wives at the time, like that she hacked Facebook. She hacked a Facebook account. And I think that it was Tabitha's Facebook account that she got into. So I think that's essentially, they're trying to keep out, 404, which is prior bad acts, saying that, it's the prejudicial outweighs the probative. That's the argument.
There's nothing modus operandi about any of the evidence that the state seeks to admit. As far as common scheme evidence, Your Honor, the Hartman case is also instructive on how this court should rule. Other acts that are admissible for a plan.
Hold on. Except for that, if I remember correctly, part of the reason that all of this was set in motion had to do with conversations that occurred between Tabitha Wagner and Hanna Rhoden. Those are the private messages that Angela Wagner was wanting access to, and it's because of some of the things said in those DMs between Tabitha and Hanna Rhoden that in Angela's mind, solidified something that she was already thinking and spurred her on to continue with her actions. And in my opinion, these are things that she would have discussed with her husband, because Billy was very much a part of this whole thing. But let me stop interrupting.
Must be so inextricably linked, and the other acts must be of the nature that they are carried out in furtherance of the same overall plan. Evidence of a common plan design refers to a larger criminal scheme, of which the crime charged is only a portion. That's what the Hartman case held. The Bill of Particulars, Your Honor, informs we as the defense that the charges we have to defend against, specifically the engaging in corrupt activity charge, stems from January 1st of 2016 until November of 2018. The engaging in a pattern, that conduct that is specifically mentioned in the Bill of Particulars, does not encompass date ranges for things such as citing gas, for things such as Jake's controlling nature of Hannah. It starts on January 1st of 2016. For the court's reference, not when Sophia was in the womb, but rather Sophia was 2 years old in 2016. And so as such, there is no evidence of any type of common plan or scheme that the state seeks to introduce with this other act evidence. Your Honor, we would submit that as far as the state goes with Tabitha and Elizabeth Wagner, we would submit that those same arguments stand with respect to modus operandi. With respect to the various other acts that the state argues concerning the Wagners, the state tries to argue the definition of relevancy for proving criminal enterprise or conspiracy in its response. Yet, Your Honor, criminal enterprise, consciousness of guilt are no exceptions to 404B. The court has a blueprint for how to analyze each and every one of these other acts. First is it relevant? Second is, does it tend to show propensity? Third is there an exception, a non-propensity exception purpose? And fourth, Your Honor, it's subject to a 403 analysis, whether or not the probative value outweighs the prejudicial effects that hearing these other acts could potentially have on a jury. We would submit, Your Honor, that every single act that the state of Ohio listed in its 2021 notice of intent to produce these other acts they're not relevant, they don't meet an exception, and furthermore, when the court performs a balancing test under 403, they're more prejudicial than probative. Now, when you compare those listed enumerated acts that the state provided us in 2021 to its motion response that it provided to us late last night, there are several ones of those left out. And so if the court would like me to go one by one with respect to the ones that are left out and hear argument on those, I can certainly do that, whichever the court prefers. That's all I have for right now, Your Honor. May I have a moment?
In addition, Your Honor, if I may, it's a situation where the rubric established by the Hartman Court, Your Honor, requires that other act evidence be so related to the crime charged in this circumstance that the evidence of the other acts is significantly useful in showing the defendant's intent with the crime charge. And that's on page 58 of the Hartman case. The reason being, Your Honor, the temporal connection requirement is that the probative value of the other act evidence decreases the more it establishes that between the time of the alleged bad act and the time of the alleged circumstances here. And that's an apostasy case. And the government's requirement acts, Your Honor, don't have the tendency to prove the crime, or more or less the ones they're putting forth. And I just have a couple for the court. So the timing, as Ms. Stevens indicated in the government's motions, from January 1st of 2016 through November 12th of 2018. They say that my client threatened someone or threatened to kill them. And it's number 4 under the motion on page, there's not page numbers, on the last page indicating general things by my client and his family. Allegations that the defendant attempted to threaten to kill someone before. So the evidence that in the record run in the first trial was such that Jay said when he was a kid getting stitches, that his father said, quote unquote, to the person giving stitches, boy, if you break that stitch again, I'll break your neck. Okay, that's the type of stuff that they got in that doesn't meet any of the requirements under under Hartman or anything of that nature, especially the time constraint. There's also stuff about mortgage fraud. There's stuff each of one you can go to. I'll direct the court's attention to page 2 of some of the acts that Ms. Kenneth and the government talks about, and that's with regards to Tabitha Clayton. In Tabitha Clayton, there's 7 listed other acts concepts. But when you take each one apart, Your Honor, and you go to each one in the record, every single time there's a quote, either by Tabitha, either by Jake or Angela, indicating Billy was not involved with that. Billy didn't live there at the time. For the court's awareness, Tabitha lived at the time with George, with Jake, with Angela, and Angela's deceased father's residence. Billy did not live there at the time. Every one of the people, there's a quote, Your Honor. Volume 32, page 7529. Volume 35, page 8313. Volume 16, page 3664. Volume 17, page 3871. Volume 35, depending on the witness, page 8317. All of those, Your Honor, volume 46, page 11089, all of them specifically say about this concept, he didn't live there. He wasn't involved. He didn't have conversations with her. So to impute this to Billy, Your Honor, these are the types of things that when you get to the specifics, it just doesn't make a lot of sense and it doesn't comply with the analysis that the court has to go through, Your Honor.
All I would say, just plain and simple, they put the cards on the table. The state is trying to get this information in to show propensity, to show bad character. That's the sole purpose. There's not a nexus. There's not a connection to the crime in and of itself. You know, that was the basis, although even reading through the first transcript, there was a lot of other evidence that wasn't objected to. But it is a basis of that deal in the first trial as well, in the assignment of error, and other evidence wasn't out in. We don't see the connection. The majority of this is all tenuous. It does not connect to the inclination to prove identity or motives that Bill Wagner committed to murder themselves.
Did these issues go up to the Court of Appeals out of George's court?
Correct.
Was there a decision?
I don't believe there was a decision. I can't speak definitively.
Still pending. Thanks. Unless Neil look for it. Your turn. Go ahead.
Thank you, Your Honor. I guess, the state found its notice of intent to use other acts evidence back in 2021. I recognize that what they have done, I think, is to go through the transcript and things that came in George's trial that they think should not come in Billy's trial. And the state will readily concede that we agree that some of that will not. We're not at the point where we're seeking to introduce those sorts of things. Lost my train of thought, sorry. But when we're saying things like Billy didn't live there at the time when Tabitha was there, that's not true. There was a time where Billy was living at the Flying W to help take care of his ailing father, but he would still come over to the house every day, and there was testimony that he did arrive at the end of one of the events there. I guess my general position is it's premature for the court to make rulings on these individual issues. I believe the court has said at least a few times that you've been spending some time with the transcript. But until it's offered, some of this stuff I think came in through George Wagner's testimony, which certainly will not be coming in Billy's. I mean, George talked about a lot of other act stuff. But there are things that are. I mean, as this court knows, they're charged with a RICO case, which requires the state to establish a criminal enterprise. And, there are going to be things that are relevant to that. The same thing with the conspiracy, Your Honor. In the motion in mind that you do not have, so in other words, because conspiracy requires meeting co-conspirator minds on a common criminal objective, other act evidence indicating a co-conspirator state of mind may well be relevant to explain how a criminal enterprise developed, to help the jury understand the basis for the co-conspirator's relationship of mutual trust, or to complete the story of the charged conspiracy. Both Jake and Angela testified in George's case that it was the tumultuous relationship between Hannah and Jake, and their obsession with Hannah and Jake's child were the primary motive in the aggravated murder. So again, some of this stuff too, you know, that I, in the notice of intent to use other acts of evidence, really isn't even other acts of evidence. I just threw it in there out of an abundance of caution. You know, the fact that they're controlling of the females that come into their life, in the state's opinion, is a behavioral, you know, fingerprint. They have a definite playbook when it comes to dealing with the females, Hannah, May, Tabitha, Plater, and Beth Ann Wagner. You know, and that playbook gets repeated over, and it ultimately culminated in the death of 8 people. Because it was when Hannah May said, "I will not sign custody papers ever, they'll have to kill me first," that the wheels got set in motion. That was December of 2015, and by April of 2016, Hannah May and 7 members of her family were dead.
Okay, so I have to interject here for fair use commentary, but this is what she just mentioned. Hannah May saying, Hannah Rhoden saying, she said to Tabitha in those Facebook messages. And so the state, in my opinion and estimation, as I understand the law, and I am not an attorney, so you just need to know that outright, but the way that I understand it, that's why this needs to come in. Because this is that exchange between Hannah and Tabitha is, for all intents and purposes, in my opinion anyway, the straw that broke the camel's back, as it were. And that is what really pushed everything that happened after that. That is the one, that is the conversation that I think really set all of this in motion. If there was ever an opportunity, I think they were thinking about it prior, but I think that the conversation solidified in Angela's mind what needed to happen, is what I should say. And Billy participated, so obviously he was aware of it.
As a result of that resistance to control that the Wagner family exerts. So, you know, I guess, you know, the modus operandi, you know, with some of the arsons and stuff like that. I know the state argued this in Georgia's trial. It's the same thing. They plot, they have a plan, everybody has their role in the process. After the crime has been committed, they work to cover it up and come up with a story, you know, to put out to the masses or to the law enforcement should they come around. So, you know, that is exactly what we see going on here. And again, that kind of goes back to that criminal enterprise. They're constantly committing crimes for financial gain or other purposes. In this case, you know, to establish control of this child that was no longer in their 100% control. So again, Your Honor, I think it's hard because at this point we've not sought to introduce anything. I don't think that everything that came into, you know, in George's case, I mean, the poaching deer or actually the one thing that Mr. Collins just mentioned, he pointed a gun at somebody. We never put that in George's trial. In fact, I would say that number 3, instance of defendant threatening Angela Wagner with a gun. Number 4, this is under, in the notice of intent to use other evidence with kind of the general catch-all thing that I have at the end of that. Allegations that the defendant has plotted, threatened to kill others before. We did not bring that into evidence. I would not seek to introduce that. Defendants involved in transporting drugs and engaging in drug trafficking. We know that the story of the night, you know, at least according to Jake's testimony, was that, you know, they were meeting Chris to do a drug deal or to firm up plans for a drug deal. We think that that was a fictitious drug deal. but that Chris Rhoden believes was illegal. So there are some of those fringes, but again, at this point, we're not, seeking to admit all of these things that are listed here. But the ones that we would be seeking to dismiss, Your Honor, again, specifically relating around, and I would also say that it's certainly relevant, because again, that was their motive. It also goes to their motive, which is another permissible use of other acts evidence. And they freely admit that that was. I mean, it's proof of motive, opportunity, intent, preparation plan. That the controlling of Hannah May was their motive when they found out that she was going to resist that. So, some of this stuff is extremely relevant and goes to making it more probable than not. And I would also say it is not so inflammatory or prejudicial. It's not like I'm saying, oh, he killed somebody else, or he did this, or he did something really horrible. But they would be like, oh, well, he did that, and he did this, which is the concern with impermissible or acts evidence. That's the propensity stuff. It's not what the state is seeking in this case. First of all, some of it is just to tell the story, and I have that quote, and I don't know what it is.
Okay, so what Ms. Canepa is arguing here is that the evidence that they're seeking to introduce isn't evidence of prior bad acts, which suggests that Billy Wagner is the type of, because he committed prior bad acts, that he is the type of person who commits bad acts. So therefore, he must be, he's more than likely guilty of these specific charges and crimes that he's been charged with. That's not what she's saying. What she's saying is that this evidence actually goes to their motives and the way that they do things, that they make a plan, they work together, each person has their role, and that not only does each person have their role, but their role is important. And if each person doesn't fulfill their specific role, then the plan falls apart. That's what she's arguing, and I think she's right. I don't think this is prejudicial evidence at all.
But, to complete the story of the charged conspiracy, but it tells you, evidence shows that the tumultuous and strained relationship with Hannah, and more specifically the Wagner's motive in committing the aggravated murders. The murders were the final culmination of their jealousy, possessiveness, and control. And that is it can be relevant just to give background on the relationship or information on the relationship and as it developed. So again, some of this I don't even think is fact evidence. Some of the more specifics, he's saying, well, Billy wasn't there or this or that. I would agree in some of those instances that would not be permissible. But again, there are times where, they all conspired to commit these murders. They all were doing separate acts. They weren't always together when they were, buying a murder truck or building the silence or, making purchases. So from those aspects, I think those pieces of evidence would come.
Listen, on if I might say your name, sports is the only way down here to Pike County today and sat in the corner this morning. I'd just like to say, I think the one word, and I'm not sure we used it premature, I think, is a guidepost here. Some of the things, obviously, that are described by Mr. Collins, certainly, if they were used in George's trial, won't be used in Billy's, by my view of it. I had not been through this transcript, and some of the other things that Mr. Collins identified that he wasn't there. So what? I could hire him to commit a murder, be in New York City, and the murder happened here, and the fact that I wasn't there when it was committed is irrelevant. And certainly, if I'd done that 6 times before because I'm a monster trying to kill people off in a drug conspiracy, me being there or not being there or living there or not living there is totally irrelevant. to whether or not other acts is admissible. So at least I think I understand what Mr. Collins' concern is, and understand that the court doesn't want the state to go astray from what the counts are in the indictment with other evidence of acts, but the Facebook, for example, surveillance that might constitute telecommunications fraud is a count in the indictment. That's not another act. So that clearly would be admissible. The forging of documents on birth certificates is a count in the indictment. That's not another act. So I think they have mixed together certain things claiming them to be other acts when they aren't other criminal acts by the defendant that are under 404B, but rather they're state's evidence to prove the count in the indictment. So that again goes back to where I started, that I think if the court's going to review this and write a decision with certain broad guidelines, that might be the proper, but otherwise I think that it really is premature. And I think at the last hearing, Mr. Collins even said that this was something that might be able to be considered through the flow of the trial as the issues arise. So unless the court has any questions, I would have nothing to do about that.
Thank you, Mr. O'Brien. So I articulated my reasons for saying that the death penalty specification should be dismissed. Number one on the list was listening to lawyers seemed to make that an easy no-brainer, and then I found out that listening to lawyers isn't always advisable. Or when we do so at our own risk. So that was the beginning of a cascade downward into the Court of Appeals, which is fine. I appreciate the fact that they can help guide the trials along the way. But Ms. Kenneth, I thought that that was like without enough notice. So if you want to have a record, you're welcome to caution me about not believing what lawyers tell me. So you want to straighten me up. I set the death penalty aside because I heard for months, Mr. O'Brien, that the lawyers, you were here, would actually, 100%, yeah, I appreciated the fact that you were willing to encourage me to delay and give you some more time, and maybe that's still appropriate. But I did grab a hold of the fact that you thought you didn't have adequate time to argue, so I gave like the obligatory 10 points, literally 11 points, about why that seemed to be necessary and appropriate. And if she didn't get enough chance to answer all those points, I'm going to revisit that just so like I can make sure she can advocate. So just picked up and said we're all here, and the court reporter's got fresh fingers. She can write down whatever Ms. Kenneth would like to do to set me straight. I only acted in like reliance on lawyers, not hoping to embroil the Court of Appeals in what I already called invited error, but that's at a different level. So scold me for listening to you, actually.
Well, at least, Judge, I think my view is that since the notice of guilt was filed, that the state would not be able to add or supplement the record, and the court would not be able to do so either.
But my notice went on before yours that I was going to reconsider. So you don't maybe have a final order. I can still hear this. I don't have to act on it. But in fairness to you, I'm not going to interfere with the Court of Appeals. I said to you all I wouldn't interfere with the appeal, but I would keep this trial moving. I didn't cancel any dates. We got a lot of work to do. So while the Court of Appeals is doing its job, I can still have the second track. But if I went afoul, then we still have time to fix me. So fix me.
Well, at least, Judge, I think that it's proper for the court to hear this motion under 404B in limine today, because that doesn't involve the issue that's in front of the Court of Appeals. But at least my view is since the issue on whether the death spec should have been dismissed under those circumstances at the time is in front of the Court of Appeals, that we would not have jurisdiction or ability to supplement the record, argue the record, for the court make other findings or defense present something further. So at least with that view, I don't think the state would have any further to present.
So like my understanding is I can't act in contravention of the notice of appeal. But hearing argument, taken under advisement, is not an act.
All right, back the milk truck up a little bit. Am I understanding this correctly? This judge decided that he was going to remove the death penalty specification, taking it in effect off of the table as a consequence. The state has appealed that decision. That decision is now in the appellate court, but homeboy wants them to argue it in front of him, like as if he's going to change his mind. What is the point of this? It's in the appellate court. What are you doing, Judge Hine? Are you just trying to get this? This feels like, I feel like I need to be like Admiral Akbar right now. That's a trap. Don't do it. Like, what are you trying to do here? I don't understand. If he is, I believe he will be the one presiding over this trial, and as such, this is going to be a dumpster fire. Here we go.
This is how I see the law. Like, I wanted you to have the opportunity to make your record, so we don't have to schedule another hearing and waste more time, have further delay. So I won't act on this. I will just hear this, take it under advisement, let the Court of Appeals give me further guidance. Like, I expect lawyers to be doing 5 different tracks of work simultaneously, not one thing at a time, followed by one thing at another time. Otherwise, we don't get anywhere. So, like, I run 4 different railroads going the same direction.
Yeah.
And that's what I think.
You don't run look, are you confused about where you are? I mean, I understand that this is an analogy, but no, this is not how this works. Okay. What he's trying to get them to do, this is what it sounds like for me. And again, I'm not an attorney, but I have watched a lot of trials. What sounds like is now it is sitting with the appeals, the Court of Appeals. Okay. His decision is. What he wants is whatever their decision is, he wants the state to go ahead and make arguments ahead of that decision, which makes no sense. You can run 4 tracks if you want to, but the fact of the matter is, Your Honor, that this specific train ain't on neither one of those 4 tracks. It is at a whole different station. So there's no use in talking about a train that ain't in the station, bruh.
What we have to do is run multiple actions simultaneously. So I would invite you to help me understand better how it is I went foul, so I can fix it faster to keep the railroads running.
You had no. You had that opportunity. When you decided that you were going to remove the death penalty specificity from this case, okay, Ms. Canepa stood up and she argued as to why that would be detrimental to this case and why she didn't think it was right. She already did that. And you said some gibberish about trains and tracks and when you got to rein it in and this is taking too long and I got to exercise my judicial control because I don't even remember what you said, honestly, because it was so ridiculous. But the gist of it was this was taking too long and you were going to exercise your judicial control and you were going to get the train back on the track and into the station at the right time, and it was departing now, toot toot. That's what you said. And now you want them to make some argument as if you're going to change your mind. No. You've already done what you're going to do. You've made up your mind. It's out of your hands now, bruh.
You could have set aside your dismissal of the death sentence, and that would interfere with the jurisdiction of the Court of Appeals.
If I did that in advance of their decision, maybe, because it's not contrary. In essence, I'm giving you trial level. I wouldn't do that. I told them I'm not going to do that. But you don't want to argue now what you wanted to argue before. I'm not going to make you argue, but I might not give you another bite at the apple later, I might call this a waiver if you don't want to give me the argument today. I'm not saying what I'm going to do. I'm just saying there's 4 railroads running the same direction simultaneously. That's how I work. So I would be curious in having this railroad loaded up and ready to go while I'm working on the other railroad, other acts testimony.
Wait a minute, back the milk truck up. Or back the train up. Hell. So now what you're saying is, in a very veiled threat kind of a way, that if they don't argue this motion ahead of the appellate court's ruling to you, that you may take that as a waiver, that they're fine with the death penalty specifications being removed, although the appellate court hasn't made its determination yet? What are you doing?
Well, I'm already working on jury instructions while I'm already getting ready for a different venue. There's more than 4 railroads running one direction in
You ain't ready to be a conductor, sir.
my mind, and if everybody's used to doing one at a time, shame on you, because we can't. Nothing personal, but I run into a lot of lawyers who can do one thing at a time before they do the next one thing at a time, and that's why they're slow, and that's why I can't do that, because like I'm here to.
So Rachel asks, so what are they supposed to be doing right now? Well, in truth, this whole situation, what they're supposed to be arguing is about prior acts and a change of venue. That's what they're supposed to be arguing, because, point in fact, the argument over the death penalty is no longer being had in this court. The argument has gone to the appellate court, and the appellate court is the one handling that. And they have not made their decision. So I don't know what he's trying to do. I don't know which train we're on. I don't know if there is an actual train. I don't even know if we're at the right station. I don't know. He's got 4 trains running in his head. That I can tell you. That's all I can say.
Get this case done properly, timely. So I want to run like multiple railroads.
Well, I think that's proper, Your Honor. I guess the railroad dealing with whether aspects are in the indictment or dismissed is out of your hands, in my view.
It is.
That railroad is in the 4th district. Is this the 4th district?
Okay, so you don't want to argue further. Okay, good. I'm not saying I won't give you another hearing. I'm trying to be efficient.
Okay, well, I understand and appreciate that.
Yeah, no, 100%. I'm trying to be efficient. Like I got everybody here on a date that was scheduled last June. We're right where we're supposed to be through today. Let's use the time. But I get what you're saying, so you can be comfortable, sit down.
Okay, thank you, Your Honor.
Your respect was appropriate, as I would understand, Mr. Ryan. Thank you for that. You don't have to. I'm going to go to Mr. Collins or whoever wants to speak to it from your side. I don't think it's fair. I'm just trying to give you a chance to make a record.
Y'all, how many trains are going on in the camera operator's mind right now? Because this is all over the place. Like, I'm getting Blair Witch vibes. Stop.
I don't believe you ran afoul. At the prior time, we had filed a motion to dismiss the death penalty sex based on the agreement that was made by the government and Hitchhiker. The representations that were made were consistent since you've been involved in the case. There were some misrepresentations made by the government in their motions to file. Specifically, our client knows that the government's listening to every one of those phone calls, so he likes to mess with them, so to speak, and things of that nature. So, but we were in good faith. We've always been in good faith, and our client in our communications that I can't go into was acting in good faith as well with us, and we were all on the same page. So, I've had communications since that indicated they would get me a thing, get me another, get me the agreement, get me anything. I've never had anything. It's just a shutdown. We believe that. We don't have a lot to argue, Mr. Davis.
The only issue that I have is when the state was started, after they reportedly listened to some of Billy Wagner's phone calls, which we never received, there was an insinuation that we were always acting in bad faith. And that's absolutely false, and we take issue with that. Without getting into the communications with Mr. Wagner, we acted in good faith. We were proceeding in good faith. We had an intention to go forward with a trial in the state with the death penalty specifications off the table. It, in essence, deprives us, we believe, of due process to try this as a capital case. Halfway through the trial, they remove the death tax. So we were in agreement to do that. There was communications with the state. They were going to get us back another record. We never received that, and we were here before. But it was another agreement. It was our intention to have that completed before that court date. So at no point in time was there any bad faith on the defense, and that's what I teach.
Thank you very much.
Your Honor, if I may,
Yeah, go ahead.
certainly, this case was started as a court notice on November 20th.
In good faith, we had an intention to go forward with the trial on this date with the death penalty specifications off the table. It, in essence, deprives us, we believe, of due process to try this as a capital case. Halfway through the trial, they removed the death tax. So we were in agreement to do that. There was communications with the state. They were going to get us back another record. We never received that, and we were here before. But it was another agreement. It was our intention to have that completed before that court date. So at no point in time was there any bad faith on the defense, and that's what I teach.
Thank you very much.
Your Honor, if I may,
Yeah, go ahead.
certainly, this case was started as a court notice on November 20th.
Oh, this might not be a Jen Lou issue. This might be a situation. Let's just see. Let's go for it just a little bit.
Thank you for that professional statement.
Oh, come on. Hold on. Let's just hope it gets unstuck.
At least was saying on jail phone calls that he was not going to enter into any such agreement.
Thank you for that professional statement.
Oh, come on. What's happening here? Yeah, it's not me. I don't think.
So I'll acknowledge that the other act's decision is likely to be couched in terms of an in limine, as it should be, advisory opinion. For everybody in the back of the room that don't speak, lawyers speak. We're trying to decide in advance what's relevant evidence. But the reality of it is you don't make that decision until you get to the courtroom and have the full context. So when they
Hold on a minute. Can y'all hear me? Am I doing okay? All right. If there was any doubt in anybody's mind as to this judge's behavior and why he is saying the things that he is saying, all doubt was removed from my brain the minute he addressed the people in the back of the courtroom that don't speak lawyer. Now, I am not an attorney, but I understand lawyer. I understand how the rules of evidence go. I understand trials. I would never try to represent myself or anybody else for that matter in a case. But what I'm saying is I understood what he said, and I feel like a lot of his behavior, in fact, I would say 99.9% of his behavior is for the cameras. So judged.
That's what we're trying to sort out. It has a lot to do with the nature of the charges, has a lot to do with the scope of the indictment, but it's going to be advisory. It does help because, frankly, we've got to make sure we're efficient when we try the case. There's no sense bringing in a witness from someplace that's going to take the stand and find out in 30 seconds everything they want to say is not coming in. So I'm pretty much a harper on make the railroad.
Sir, did you want to be a train conductor instead of a judge? I mean, is that what you wanted to do? Hold on a minute. Let me pause you. I don't want to interrupt any of your gibberish. But is that what you really wanted to do as a career? Did somebody make you go into law? Because all you do is reference trains a lot. And I feel like there's an underlying reason that maybe you secretly really wanted to be a train conductor and somebody made you be an attorney instead. And I'm sorry for that. I mean, it's not too late. I suppose you could still be a train conductor. I don't know what the criteria are.
Would you want a written response to the governor's motion from us? Would that help? Or
You might have something there, Patricia. I just kind of feel like, that this guy might be humming, I've been working on the railroad all the live long day. Like, it runs in his head the way Kyle's mom runs through mine.
Ms. Stevens is going to do it.
Thank you, Your Honor.
Just when I think it's going smoothly, boom, they do this. Hold on, let me see.
The decision, looking at the indictment, how to get a different motion later on under Rule 15 and 17, wherever they are, then the whole apple cart goes up in the air. I don't know the answer, just saying.
Oh God, now we have apple carts.
Wherever we are at the moment. Good luck to me. When we get a decision from the Court of Appeals, whatever it might be, I don't expect to give you the luxury of a lot of time. With all due respect to any other judge who's whatever short.
Would the court have any indication of what short means? Only for, I can't speak for Mr. Hayes, since that's the point, or Mr. O'Brien, Mr. Neville, but I know the month of March, and the February month of March is a police shooting. Entire month of May is a police shooting. Entire month of July is a police shooting. I'd be happy to go between, but any help the court may give, those individuals.
I mean, yeah. If we're going to be talking about apple carts while we wait for this to catch up, which apple? What kind of apples are we talking? Gala, Fiji? It's not. It's not you. It has. I don't know if if it's me or if it's just the feed itself. Rachel, I don't know, babe. Like I need to know. Granny Smith. Delicious, golden delicious. What kind of apples are we talking about if we're introducing apple carts to the train tracks all of a sudden? This seems really wrong to me, but what do I know? And then the poor defense is like, hey, we got other trials going on.
Anything I do is going to make everybody else's life uncomfortable. Thank you for the offer. I know it gets both ways, 100%. I'm going to call any judge and scream at you and use my best manners to explain my problem. But that's...
I don't know, Rachel, I don't know what's going on in this courtroom. Shenanigans is what's going on in this courtroom.
I don't know the answer to that. I mean, it's not, I don't have, but it's going to be advisory. Full context, so when they... It has a lot to do with the nature of the charges, has a lot to do with the scope of the indictment, but it's going to be advisory. It does help because, frankly, we've got to make sure we're efficient when we try the case. There's no sense bringing in a witness from someplace that's going to take the stand and find out in 30 seconds everything they want to say is not coming in. So I'm pretty much a harper on make the railroad.
And I think the defense attorney is just like, well, when are we going to actually go to trial. That's what we're trying to figure out.
Anything I do is going to make everybody else's life uncomfortable.
We don't care about your railroad or your train track.
It's both ways, 100%. I'm going to call any judge and scream at you and use my best manners to explain my problem. But that's
All right, I'm not messing with it anymore. Whatever's going on is going on, and I clearly have zero control over it. So I'm just going to have to roll with the punches, even though it's very annoying to me. Yeah, we don't want nothing to do with your railroad, your train tracks, or your apple cart, bro.
I have deniers. Like, I'm way out ahead of you because you don't have to be out there. But I do. Thank you for submitting your proposed jury questionnaire. Twice edited. Oh, you don't know that. I'm probably not going to give you a chance to argue with you. I'm just going to do what I got to do to get there. Thank you for helping me. Seriously, we're making progress. Everything that happens in the room isn't everything that happens.
Let me ask you guys a question while we're just, dealing with technology here. Do you have to be told you're making progress, or do you kind of know when you're making progress?
I'm totally running. And I don't have one case. You don't have one case. We all have to run.
Do you not want to run anymore?
The record for anything else. Ms. Canepa.
Yes, Your Honor. I don't know if the court.
Are you into the cups?
None of us knows how the Court of Appeals is going to rule, or if somebody's going to appeal that decision.
Well, this is unfortunate timing. I really wanted to hear what Angela Canepa had to say. Come on, what is going on with this feed?
Defense attorneys are allowed to talk to the court ex parte about fees for experts or whatever. I don't know how much they got done. This case was indicted in 2018. I don't know how much they got done.
Well, now see, Miss Canepa, if you were on the railroad, at the railroad track in the station with 4 different tracks, then you'd know that nothing was done.
For you to decide because you're the one telling me we're not going to need mitigation. So either you intend to keep the death penalty all the way through, or you intend to remove the death penalty mid-trial. And now if you're saying it's definitely not negotiable, I want to know if it's not negotiable.
Oh, no, I'm not saying.
I don't know, Rachel. I don't know why he's doing any of the things that he's doing. But I feel like...
Says that I will dismiss the suspects if he testifies. If he doesn't, then I would not. So that's not that's always been the case. That's never been different.
Talk to all those people out there. I don't read social media, but like every time I get more information about the done deal, dismissal, withdrawal, it helps me understand the validity of the statements that we're not going to be doing this. Like every time you come in and tell me more about ethical problems, ineffective assistant counsel, and now here's the terms of the agreement, I better understand how you were all too optimistic in your assurances that we weren't going to be there. So I'm not going to, I get your problem. I'm not going to have that answer, but I would consider that a strategy. So thanks, you have a different time.
Yes.
Go.
I would like to amend the bill of particulars. The count 6, 7, 8, and 13 should say Scioto County. It's in the transcript.
He doesn't know what they're talking about, but he probably is loving this.
But when, the court asked for the bill of particulars, and I was looking through it myself for the other act stuff, it's possible I've done that already, but I don't know that I have done that. So I would move to amend the bill of particulars.
How do you want to handle that? This is year 9, right?
Sorry?
This is year 9.
What?
On the 9th anniversary, right?
Charged
Yeah, the facts happened in the 60s. Okay. I'm just like being a little bit snarky at the moment.
No shit.
Because I can see it in your face, so why don't you just like have at it? The indictment's in 2018. I understand the bill. The bill.
What I was going to say is that the lead-in language to the indictment says that within or the body of Pike County, or some manner enumerated in 290112 of the Ohio Revised Code, where the proper venue is placed in County of Pike on their oaths in the name and by the authority stated. So,
How do you want to handle the request for amendment? You want it in writing, and then you get a response in writing?
Yes, sir.
Yeah, like, I get where we are. Didn't see that one coming. But that's why I asked for bill particulars. Like, I'm to the point now where I can drill deeper into all the stuff that you're years ahead of me on, if in fact you're ahead. So she's going to file a written motion to amend the bill particulars, and you want how much time? Okay. And then how much time behind it did you want for your very capable staff?
7 to 10 days.
Okay, we'll have a good, solid record of what we're asking for.
He's the one wasting the most time with his pontifications of nonsense.
Brian looks like he's got one.
No, I was asking Ms. Knapp if similar to the court later, there was anything, so I have nothing further, thank you.
All right, anything else?
Oh, thank you very much.
All right, thanks again to the court staff. Go ahead and stand adjournment. Oh, no, we won't. Let's talk about our next scheduling. Phone call, do that. I'm going to do it right now.
I mean, Billy ain't going nowhere. He don't care.
Calendars and phones and things like that.
You know, it's only when I see Billy Wagner how nothing, Rachel, nothing. Because there's been no ruling. Lord help us. Y'all, let me turn this down a little bit.
It doesn't seem to be a good way to ease into it. We still have cascades, so we have 3 weeks. Now we're not going to read.
I mean, to me, it seems like literally nothing was accomplished. Like, it doesn't seem like there's any orders.
You're the one with the busy schedule. The judge does not every other week, maybe a few, let's say,
But I want to hear when their next thing is, so.
It's going to be like 0 to 150, right? So like before you can be ready for the acceleration.
Bruh.
Yeah. Like I'm now going to think I'm supposed to see. It's like if you sell us a card. What's happening?
Oh my God.
We're going to do other stuff. We're going to do other stuff. We're going to do other stuff. We're going to do other stuff.
What other stuff?
Did you read my decision? The person has that I would respect to stay on the issue of someone's appeal. I should. Someone I would not stay all around. I didn't pick the kind of I don't
the one they used to check. Was he coming out of the box? I'm like, what are you laying on the floor to take that picture?
Uh-oh. What's happening here? Why are you muting? Ma'am, this was literally the worst timing. What are you doing? I'm so confused. Does she not see that big ass camera? I mean, or is the whole thing being recorded via phone? So she's not sure. What is happening here? Man, I'll just get back to you guys tonight with whatever it is, how this ended, because I can't even figure it out. It's just ridiculous. Look, this is what we were supposed to be doing. We were supposed to be hearing, ruling on some of the evidence and its admissibility. Now, while he is correct, obviously, and I really don't like saying this, but he is correct. There is certain evidence that without knowing the full context of the evidence, you can't rule as to whether or not it may or may not be admissible, okay? Because neither side, neither the state nor the defense, has to inform the court of their quote unquote strategy, okay? So there's some evidence that does have to wait until the actual trial and for it to be introduced as evidence before there can be a ruling on it. So there's that. Now, that I understand, but it feels like none of the evidence that they were actually, specific evidence that they were actually arguing about was ruled on. I don't even know when the next status hearing is. I have no idea when they're going to trial. The other thing is, this is what I think. This is how it's coming across to me. The way it's coming across to me is that Judge Hine knows that the appellate court is likely going to overturn his ruling. And what Angela Canepa is saying is that with respect to the death penalty, first of all, I'm not fixing it and Mr. O'Brien, I'm not fixing to argue about the death penalty specifications with you, because this isn't the proper time or place to do that. That motion is sitting with the appellate court. And until the appellate court makes their ruling, I'm not saying anything. And that, my friends, is the perfect example of the right to remain silent, and you use it. Except for you criminals out there, don't use it, because I love to roast your interrogation videos. And the more you talk, the better content it is, frankly, although sad, because there's always a victim of your crime. That part is sad. Your tomfoolery is not sad. So that being said, his issue, as I understand it, is that while there is a plea deal, or there was at one point, now they've been sentenced. So while there was a plea deal, the state had the death penalty as leverage over Jake and Angela. And the only way they would remove the death penalty was if Jake and Angela testified during trial, right? And truthfully. I think his issue is a couple of things. So you're going to go for the death penalty from the beginning, and you may or may not remove the death penalty, because it's, at the end of the day, it's still up to the state to remove the death penalty. So I think what the judge is saying is, and now that he has sentenced Jake and Angela, there is no guarantee that they will testify. So that presents an issue. I think the judge's issue is in picking the jury. So when you have a death penalty case, right, you have to pick a different kind of jury. You have to pick a death penalty qualified jury. That takes a little more time, and the jury pool has to be bigger, because while you can get people to come and sit, the length of trial is also a factor. So with George's was a rather lengthy trial. So while you can get people to show up and not try to get out of jury duty, right? And agree to, say, a 6 weeks trial or a 3-week trial, okay? That doesn't mean that that same group of jurors will also agree or will also say, yes, if I'm able to find this defendant guilty, I can and don't have a problem imposing the death penalty. Those are two very separate issues. And they are for many, many people. There are many people who fundamentally, for whatever reason, and they have valid and justifiable reasons why they don't support the death penalty. For me personally, I'll give you an example. If the victim's family is supportive of the death penalty, then I support what the victim's family wants, okay? But for me, the death penalty is not a detractor. States that have the death penalty don't have less murder. Okay. It's not a deterrent, is what I should say. If somebody's going to commit murder, they're going to commit murder, and they don't give a rat's fat kneecap what the consequences are. That's number one. Number two, you have to get a death penalty qualified jury, which takes more time and it can be more expensive. Number three, after, let's say that the defendant is convicted and then receives the death penalty, then at that point, the appeals process is automatic. There are automatic appeals that go with receiving capital punishment. If a defendant chooses, Eileen Warnos comes to mind, if a defendant chooses to stop the automatic appeals process, that in itself is an extra additional procedure. Then you have on top of it the time factor. When we're talking about these automatic appeals, there are some states whose appellate courts are so overloaded and backlogged that the person on death row is actually more likely to die of old age than to actually have capital punishment administered. And then we've essentially wasted all of this time and all of this money. This is what I think. I agree with this. If there's going to be a death penalty case, I think there should be a paid group of professional jurors for death penalty cases, the same way that there are long-term special jurors picked, for grand juries. That's what I think. I think it would make the process more smooth. However, like I said, I support whatever the victim's family supports. So if the victim's family wants the state to pursue death penalty, they do. The judge's issue is, what is the sense in doing all of that if Jake and Angela testify, and after their testimony, you then make a motion like you did in George's case to remove the death penalty? What is the purpose and intent of going through the motions of getting a death penalty qualified jury if in the end you yourselves are going to remove the death penalty? And I do sort of understand that, okay? However, when the judge did his sentencing, when he sped up the sentencing by making it today rather than after Billy Wagner's trial, what he then threw into question is whether or not Jake and Angela will testify. And quite frankly, with Billy and with George, both really, the state they need Jake's testimony more than they need Angela's, and that's just facts. Jake is a witness to the crime. Jake was there at all 4 crime scenes. Jake knows what happened. He knows who did what, when they did it, and how they did it. And that's just the way that it is. Could they prove their case without Jake? I think they could, but if they were seeking the death penalty, I do think that they would get a verdict of guilty in Billy Wagner's case without the testimony of Jake or Angela or Jake and Angela. What I don't think that they would get is the death penalty. I don't think that the same jury, while they might be able to find Billy Wagner guilty, I don't think that they would be able to recommend the death penalty without Jake's testimony, without that eyewitness testimony. Because what they do have is a lot of circumstantial evidence. Make no mistake, circumstantial evidence is good evidence. I mean, obviously, there's caveats to that. I mean, what exactly the circumstantial evidence is will denote the quality of said evidence. But people sometimes tend to think that circumstantial evidence is less credible evidence or doesn't carry or shouldn't carry as much weight as direct evidence. Direct evidence being, DNA, fingerprints, etc. And there is no DNA or fingerprints at these crime scenes. Okay. So that I get it. But to then circumvent the whole process and just say, well, you know what, you're going to end up removing the death penalty because these people, like I would have been more supportive of his decision if he had not accelerated the sentencing of Jake and Angela. If he had left the deals the way that they were, where they will be sentenced after Billy testifies, right? Or excuse me, after Billy's trial, after they testified, then I would probably have supported his decision. I might not have agreed with it all the way, but I would have understood it and I would have been like, okay, this makes more sense. But that's not what he did. So it's all a mess now. And that's why I'm frustrated. And also I'm frustrated about the way that he treated the victim's family today, the family members today. And this isn't the first time he's done that. When he made this sweeping decision to remove the death penalty, before he did that, he spoke directly to the victim's family members and basically said, I don't give a rat's fat kneecap what the state and the defense have agreed to. I don't care. I'm going to do what I'm going to do. And I'm under no obligation to honor anything that the state and the defense has agreed to with respect to these plea deals between the state and Angela and Jake Wagner. I don't have to do it. And I'm not. And that was like a huge, indicator when he made that speech about that he was fixing to do something. He's like, it's that no different than somebody saying to you, now, no offense. And then they say something highly offensive and foul in the next breath, right? The next words out of their mouth offend, everybody, right? So that's what he did. And that's what I'm frustrated about, especially when he continues to use these terms like, we need to be doing multitasking, running multiple trains on multiple tracks simultaneously, we're not handling one thing at a time. And then he introduced some apple cart situation, which I don't even really know what that was about. And it made no sense to me. No, just kidding. I understood what he's saying, but it's still ridiculous. I don't agree with it. But then at the same time, he goes off on these sidebars and addresses the people in the back who are not lawyers. Or he gave the victim impact statements 10 minutes, then admonished Angela Canepa, or Miss Canepa, I should refer to her properly. I don't know her like that. So admonished Miss Canepa for reading one of the statements from the victim's family members too quickly. Because what she was trying to do is allow any victim who was there in person to say what they needed to say and make sure that there was enough time for them to do that. And yet he still punished her. You're reading too fast, So there's that. It's just like he says one thing and does another. He's very, he contradicts his own analogies, his own. It's just ridiculous to me. And it's like my brain is hurting from listening to him. Like, how are you going to say, I want to speed things up, and then you run off on some kind of tangent about, train tracks and apple carts when you're a judge, bruh? You're not a train conductor. That's a poor analogy, an extremely poor analogy. The train wasn't derailed. It wasn't before. It was going along. You might not like the progress or the speed at which the train was traveling, but you, sir, are the one that derailed the train, as it were, to use your analogy. Nobody else. Correct. And to add insult to injury, he allowed Jake to go on and on and on. And then had the unmitigated, bless you, babe, unmitigated gall to, at the end of that rambling, served one purpose, and that was Jake, there to then say, I heard remorse, which I don't know what ears you were listening with, sir, but they were not ears that the rest of the people in that courtroom or watching in this chat or probably any other chat heard. None of us heard remorse. Okay. You got that big judge's robe. I feel like up underneath that judge's robe is just, that's why it's so big and billowy, because it's filled with audacity. It's ridiculous. And then after all of that, your idea, you didn't like the plea deal between Angela Wagner and the state, and you didn't like the sentencing recommendation provided by the state, which was 30 years. Okay. So your remedy for that, because as you said, she could have stopped the whole thing. She had all of the phones, so she could have called somebody. Well, point in fact, Billy, George, and Jay could have all stopped things as well. A, they didn't have to go, or B, when they were in the planning stages of all of this, they could have just called the cops then too. Since we're handing out people stopping other people. Then you admonished Angela for not stopping anything, and you complimented Jake Wagner, who's the one who actually pulled the triggers, who also did some really grotesque and heinous things in the commission of the crime. For example, the situation with the children. The fact that he fired upon two adults while a baby was in the bed is unimaginable. I just cannot even begin how that poor sweet baby wasn't hit. It was a true miracle. Okay. And your remedy for all of this is to give the trigger puller a chance at parole after 32 years, after you've shamed and re-victimized the victims' families. You spat on the victims in this case's graves. You said their lives are only worth 32 years. That's what you said with that sentencing. 32 years. And all because Jake Wagner decided to come forward and testify, saving his own skin as well. He didn't just do it out of the goodness of his heart. They took the death penalty off the table for him as well. That's what you did. And then after doing that, you have on top of all of that, then you have the nerve to turn to the victims' family members and say with a straight face that you hope that this brings some closure to them, which is a ridiculous notion. There's, in my opinion, when things like this happen, there's no closure. You just learn to live with it, So you did that. I've never seen anything like this. I am like flabbergasted at the level of audacity that this judge is carrying around. And you referred to the things that the victim's family said as ill and what's the other word? It was started with an R. That is the word. Those are the adjectives that you use to describe their feelings towards the people who either directly pulled the trigger and killed their family members, or the people who had a huge role in planning and carrying this out. Was it rank? Yeah, ill and rank. As if, and then you try to like walk it back just a little and say and tell them that they were justified in their feelings. Like, get bent, bro. How are you going to tell that family, that those victims' family members, that they're justified in their feelings? That's that's one of the worst and most condescending things you could do, because it wasn't like you were validating their feelings in a genuine way. No, 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 no. What you were doing was disingenuous and you were condescending. That's what your tone was. Like the victims got up there and they said what they said and they had to get it off their chest and they were angry because it's a betrayal. Because at one point they were the Rhoden and Wagner families were one family at one point, because they had Jake and Hannah's child in common, but also these families go back to living in that area for like generations. So it's not, and they grew up together. So I just can't. It's so gross. Let me get off my soapbox because I've been up here for 5 hours and I'm tired of hearing my own self-talk. That's all I wanted you guys to know. Anyway, it is scary when families get involved and they conspired and do all the things. Cash, you're right. You're right. And the thing is, like what Miss Canepa was trying to say in her argument, I understood when she was arguing before the judge about prior bad acts and the evidence. What she's saying essentially is it wasn't just one thing, because it's never just one thing. There's layers, because we're dealing with humans. So there's layers of things that took place. There was a series of events that took place that set all of this in motion. It wasn't just one thing. And that's why, to lay the foundation for the motive of this crime, some of that stuff has to come in. Even if it wasn't Billy Wagner himself logging into somebody else's Facebook account. Okay? It's ridiculous. Patricia says he willfully ignored the profound impact of his trauma on everybody. He did. He was, if you're going to use an R word to describe him, it wouldn't be remorse. It would be repugnant. What he said up there, although I'm not knocking anybody's religious beliefs or anything like that. I'm not even knocking Jake's. But essentially what he's talked about was, while I've been incarcerated, I have gone on a journey, and I'm about to tell you all about my walk with God, while not apologizing or actually taking any real accountability for my crime. In fact, what I'm going to do is I'm going to look at you directly in your face, and I'm going to tell you how you need to have a walk with God or Jesus or both. That's really what it is. It's ridiculous. That's what it was. There was no remorse. Ugh. Anyway. So, with that being said, I'd like to thank each and every one of you guys for being here. I appreciate it so very much. If you would, please do me a favor and give a thumbs up on the stream or a thumbs down. Maybe you're tired of hearing me talk too. Who knows? however you feel. I'm not fixing to judge because all I can see is the likes and dislikes. It's not like YouTube snitches you out and tells me who did it. And even if they did, you're entitled to your opinion. And I think we will be doing a deep dive tonight. So look for that. I can't tell you exactly when. It might actually be like a late night, but that's kind of what I plan to do. I just got to see how the day goes as far as what time it'll be. But anyway, thank you guys all for being here. Have a great rest of your Friday afternoon, and I will talk to all of you later. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious. Finish her.
Minutes later.
We all do a little math sometimes.